allowing it because of change in the cost title.
Yeah, but no, the appellate side,
No, no, my lord.
We-
Company jurisdiction.
original side. Non-party affected will appeal করতে দেবে না ডিপার্টমেন্ট। দেখো কথা বলো।
The order has been passed, my lord, against a secured creditor of the company, and I am the assignee of the debt. Grateful.
Lordship,
Your Lordship, I crave leave to mention the instant matter. In this matter, we are enjoying an injunction till the end of August. However, Your Lordship, the advocate on record on this matter is going on leave from Friday because she is getting her eye surgery, both eye surgeries. So kindly list the matter.
Extension. Have you served notice?
Yes, Your Lordship.
Where's the notice?
I'll just file it.
No, bring back the notice.
Yes, Lordship.
Only then it will be listed. Yes.
Lordship, may I be allowed to mention one appellate side, specially assigned matter, my lord?
Yes.
My lord, the matter was regarding, it is a specially assigned review application. My lord, the matter happened that
No, what do you want? You want inclusion?
Lordship, listing, my lord. It
Give the
has been assigned in terms of the solemn order of Honorable Supreme Court. His Lordship Chief Justice assigned this matter before Your Lordship and Justice Gaurang Kant. Matter was taken up just day prior to
Supreme Court Chief Justice of India.
No. It was the direction of the Supreme Court that upon our Honorable Chief Justice
Very
to
well,
assign
very
a
well.
matter
Give the
before a
number.
division bench. my lord. Grateful, Your Lordship.
It was once listed, nobody turned up.
No, my lord. Adjournment was sought for on health ground. It was taken up on the last day of vacation, before vacation.
যাকে তুমি আমার সঙ্গে কথা বলে এটা বেঞ্চ করে দিও।
Grateful, Lordship.
Lord, I had concluded my submission, but not on the last occasion, Your Lordship Lord wanted to have the order that this bench had passed in respect of payment of occupational charges in another matter, ATC India. Lord, this is the judgment.
Oh, yes.
Lord, there were two identical issues, Lord, which were raised in this matter. One was, Lord, at pre-decree stage, Lord, payment of occupation charges, that was there. And Lord, the other point was under Order 39, Rule 10, the court had exercised power. That power couldn't be exercised. This is the judgment. Paragraph 11, if Your Lordships, Lord, kindly look at. Around the middle of that paragraph, sentence starting with the word, since the respondent number 1. Has Your Lordship got that? Plaintiff accepted rent. Even after license came to an end, the efflux of time, plaintiff has become a tenant in respect of the suit premises. Senior counsel submitted that only if the respondent plaintiff succeeds in the suit at the trial, he may be entitled to mean profits. And then, Lord, paragraph 15 onwards, Your Lordships will find my lords have dealt with these issues. Yeah. Yes, 17, Lord, Your Lordships, Lord, have recorded that Vijay Kumar's judgment. And para 19, or rather para 21, Your Lordships have dealt with Order 39, Rule 10. 2021, yes. In fact, your lordships have held that there is an inherent power in the court to grant lord occupation charges. There were some disputes in this matter. Therefore, your lordship directed the entire money would be deposited, but withdrawal was limited.
বাট এই গুরুগুলো কি করে থেকে যায় আমি বুঝতে পারছি না। Applicant cannot enjoy. No, we have not the respondent number once accepted such a point. I want to see the original. আশ্চর্য ব্যাপার। এই ম্যাটারটা অরিজিনাল ফাইলটা তোমার চেম্বারে আনাবে। FMAT 76 of 2025 কারেন্ট অর্ডারটা হচ্ছে 28 এপ্রিলের অর্ডার। ফাইলে অরিজিনাল থাকবে। দাঁড়াও। Yes.
Lord, occupancy charges in this case was fully allowed, but there was a dispute with regard to the maintenance charges. So your lordship said that that money should be deposited and subject to the final result that can be withdrawn. That is how, Lord, the matter was disposed of. But I am really grateful to your lordship, Lord, for pointing this out. In fact, it had slipped out of my mind that this order was in fact passed by your lordship. In really,
My memory is terrible.
mine is even worse than that.
It's so far up here.
But, may I have my lord?
Yes, yes. Yes, Mr. Mitra. Anything in reply?
Depends upon your lordship.
No. No, if you want to, and otherwise we'll reserve order.
No, my lord, I have got something to say.
Yes.
My lord, I've got something to say.
Yes.
And particularly, my lord, when I find the learned judges are against me, then my lord,
They smile.
I get the inspiration to make my submissions. My lord, I shall start off with this judgment of your lordship.
Very well.
My lord, since it is before your lordship, I think it's better, is the best thing to do. Your lordship will please to come to paragraph 3. My submission, the foundation of my submission will be on the basis of the claim of adverse possession, nothing else. Lordship will be pleased to come to paragraph 3. The appellant was a lessee in respect of suit premises under the respondent number 1. The lease deed had been executed in the year 2016. It appears that subsequently the lease expired by a flux of time, and the appellant continued to be in possession of the suit premises under an agreement described as live-in license, executed in January 1, 2023 by and between the parties. The agreement stated the appellant herein described the licensee was granted permission by the licensor, being the respondent number 1 herein, to occupy the suit premises for 6 months starting on 1st January 2023 and ending on June 30, 2023. It was further stipulated in the agreement that the licensee shall pay license fee of rupees 3,25,500 and the monthly maintenance charge of 4,49,500 to the licensor in advance within 7 days of each English calendar month. But this is of utmost importance in my respectful submission. Paragraph 2, 3, and 4, and 5. Then, my lord, kindly come to paragraph 16. Straight away, I am not troubling your lordship with the other part of the judgment. It was a case of a lessee whose lease expired and he was allowed to continue to stay in the premises on the basis of a leave and license agreement, paying a certain sum of money. Now, my lord, kindly come to para 16. However, what is not in dispute is that the appellant is occupying the suit premises and utilizing it for commercial purpose. What is also not in dispute is that till August 23, the appellant paid license fee, occupational charges, and maintenance charge, aggregating rupees 7,75,000 every month to the respondent number 1. After that, the appellant has not paid anything, although he is enjoying the suit premises. Then, my lord, 17. Nobody can be permitted to enjoy another's property without compensating the owner of the property. My lord, this is the foundation of the judgment of your lordship. My lord, now I know, my lord, the defense that I have put forward before your lordship is not a very respectable defense. My lord, your lordships, my lord, always look down upon the principle of adverse possession. A person who is proclaimed to be a trespasser, who is himself claiming to be a trespasser, and saying that I am here for the last 12 years, therefore you cannot dislodge me. My lord, that kind of a position, my lord, your lordships never, my lord, appreciate. So, my lord, I am in this predicament. I start off with a handicap. I am proclaiming that I am a trespasser. I have been a trespasser since 1993. I continue to be one. And, my lord, I continue to be one for the last 12 years. So, my lord, what I am submitting before lordship is that a trespasser who had been in possession adversely, openly, my lord, against the actual owner, he is now claiming title to the property. My lord, I will respectfully, my lord, on this aspect of the matter, I will now, kindly, my lord, take the Limitation Act once. Section 27. Well, your lordship will kindly allow me to just make my submission. I shall try and be as short as possible. I know your lordship.
No, not because of that. Then if you're citing new case law or sections, they will have to be given an opportunity.
But I will cite one case law, not a new one, that was cited in the trial court. And
not before us.
Not before your
Not
lordship.
before your lordship. Not before your lordship. I referred to it, my lord, in passing. Well, kindly come to section 27 of the Limitation Act. Extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. Section 27 of the Limitation Act. My lord, along with that, kindly come to, my lord, in the schedule, clause 65. For possession of immovable property or any interest therein based on title. 12 years, when the possession of the defendant becomes adverse to the plaintiff. Then, my lord, explanation is there for the purpose of this article. A, where the suit is by a remainder man, a reversioner, other than the landlord or a devisee, the possession of the defendant shall be deemed to become adverse only when the estate of the remainder man, reversioner, or devisee, as the case may be, falls into possession. Then 2, B, my lord, really it doesn't apply where the suit is by a Hindu or a Muslim entitled to possession of immovable property on the death of a Hindu or Muslim female. My lord, I'm not troubling your lordship. And then C, where the suit is by a purchaser of sale of execution. This also doesn't apply. My lord, therefore, my respectful submission is this, that the possession of the immovable property, my lord, this, therefore, what I am submitting your lordship, that, my lord, the legislature has acknowledged that a person who had been in possession adversely to that of the actual owner for 12 years, then, my lord, he acquires a title which, my lord, can be claimed by way of adverse possession. My lord, this is the suit that I have filed. Now, my lord, I pause here for a moment. My lord, this is a sort of, if I may use that expression, it is a precarious contention, a contention which is not based upon the actual acquisition of title. It is acquisition of title by prescription of 12 years, and you acquire title. Now, a trespasser is coming before your lordship and saying that I have been in possession, therefore I am entitled to the claim of ownership. This used to be looked down upon. It no longer is. I found, my lord, this the Supreme Court has also acknowledged this one. This is a Roman concept. It has been said that for more than 2000 years, this particular concept has been, my lord, prevalent in the legal world. In Roman law, this has been recognized. The reason is this. What they say is this. The principle is this, my lord. This is what I can say. The philosophy behind this is that a person who had been attending a property for 12 years, when the owner is not looking after it, and, my lord, had been my lord, tending the property, my lord, cultivating it, growing, my lord, fruits, etc., in that, it becomes almost a part of that particular person. So the law recognized that a person who had been in possession and had tended this a particular property for 12 years without the owner not raising its little finger, claiming possession, in a situation like this, my lord, whether the person concerned can claim adverse possession and use it as a sword, say that I am in possession, therefore I will continue to be in possession as the owner. I am claiming ownership of this. Now, my lord, this concept distinguishes the judgment, my lord, which your lordship has delivered from mine. I am not saying that I am in possession in somebody else's property. I am saying I am the owner of the property. Therefore, I am not entitled to pay anything to anybody. This is the submission that I am making before your lordship. It's a bold submission, but nonetheless, my lord, it's a submission which is, my lord, supported by law. My lord, kindly, my lord, in this connection, take this judgment. This has also been cited in the trial court. It's a rather longish judgment, my lord, of the Supreme Court, and this is a judgment of 3 judges bench. Well, this is reported in 2019, 8 Supreme Court cases, page 729. Ravinder Kaur Griwal versus Manjit Kaur. And this is a very well considered judgment in my very respectful submission, considering all the judgments earlier. Well, kindly see the question that has been put by the Supreme Court to itself and answered. Kindly come to the first paragraph. The question of law involved in the present matter is quite significant. Whether a person claiming the title by virtue of adverse possession can maintain a suit under Section 65, Article 65 of the Limitation Act for declaration of title and for a permanent injunction, seeking the protection of his possession, thereby restraining the defendant from interfering in the possession, or for restoration of possession in case of illegal disposition by a defendant whose title has been extinguished by virtue of the plaintiff remaining in adverse possession, or in the case of disposition by some other person. In other words, whether the Article 65 of the Act only enables a person to set up a plea of adverse possession as a shield, as a defendant, and such a plea cannot be used as a sword by the plaintiff to protect the possession of immovable property or to recover it in case of disposition, whether he is remediless in such a case. In such a case, in case a person has perfected his title based on adverse possession and the property is sold by the owner after the extinguishment of his title, my lord, kindly see, exactly fits in with my case. What is the remedy of the person to avoid sale and interference in possession or for its restoration in the case of dispossession? Exactly like this. The owner of the land had sold it to Money Square. I am in possession for the last 12 years. I am claiming adverse possession. I am saying I have filed a suit for resisting possession by anybody else, a third party, because I have acquired title. Now, my lord, whether that suit, when this suit is pending before the lordship, whether, my lord, it can be interfered with.
Yes.
अरे भाई जाने छोड़ो. My lord, therefore, my lord, this kindly see, my lord, it almost fits in with the case that I am making out with lordship, and the distinguishing feature from all other decisions which have been cited, where, my lord, occupation charges have been claimed, is, my lord, expiry of a lease by my lord, expiry of a lease of a lessee who had been in possession since after it. A suit has been filed, and, my lord, eviction decree. But most of the decisions of the Supreme Court are where eviction decree has been passed, and the person concerned, the lessee, who has against whom, my lord, the decree has been passed, he has gone up to the higher court for stay of execution. There, the court says that as a term of your continuing in possession, court is saying in terms of Order 21 Rule 45, or sorry, Order 41 Rule 45, I am imposing this condition upon you that you will be allowed to stay on the property if and only if you pay this amount of money, whether it by mean profit, occupation charge, whatever your lordship calls. My case is different fundamentally from that. I am not saying that this is I am in possession as a lessee or a tenant or a licensee even. I am not saying that I am holding this particular property by way of, my lord, a tenancy at sufferance. I am saying that I am in possession for 12 years uninterruptedly, never, my lord, and, my lord, 12 years have passed. By the time, my lord, Money Square purchased the property, I have acquired title before Money Square acquired the title to the property. And today, my lord, Money Square is saying that I am entitled to the possession of the property, and therefore you pay occupation charge. I say I will not pay you occupation charge because you are not entitled to it. I am the owner of the property as much as you are claiming to be the owner of the property. This is, my lord, title versus title. It is not, my lord, superior title against an inferior title. That is the difference between. This is the distinguishing feature. My lord, kindly take, I am not going to trouble your lordship, my lord, entirety of the judgment. It's a long judgment discussing various things. My lord, kindly see paragraph 2 of this. Placidum D. The concept of adverse possession appeared in the Code of Hammurabi approximately 2000 years before Christ's era. Law 30 contained the provision, and then it has gone on discussing this. Kindly, my lord, come to next page, page 740, just before paragraph 4, Placidum C, just after Placidum B. The possessor who maintains and improves the land has a more valid claim to the land than the owner who never visits or cares for the land and uses it, is of no utility. If a former owner neglects and allows the gradual dissociation between himself and what he is claiming, and he knows that someone else is caring by doing acts, the attachment which one develops by caring cannot be easily parted with. The bundle of ingredients constitutes as adverse possession. This is the concept. My lord, kindly, I am not troubling your lordship, my lord. The judgment, various judgments have been discussed, my lord, of not only, my lord, of the Supreme Court, but also of the high courts, including some of the judgments of this honorable court. Lordship, will please come straight away to paragraph. Kindly come to paragraph 34. Paragraph 34. The operation of the statute of limitation in giving a title is merely negative. It extinguishes the right and title of the dispossessed owner and leaves the occupant with a title gained by the fact of possession and resting on the infirmity of the right of others to eject him. Then Perry and Clisford has been considered. Kindly come to my Lord Placitum C in that on that page. It is settled position of law laid down by the Privy Council in Perry versus Clisford. It cannot be disputed that a person in possession of land in the assumed character of owner and exercising peaceably the ordinary rights of ownership has a perfectly good title against all the world but the rightful owner. And if the rightful owner does not come forward and assert his title by the process of law within the period prescribed by the provisions of the statute of limitation applicable to the case, his right is forever extinguished and the possessory owner acquires an absolute title. My Lord, I am, my Lord, claiming an absolute title to the property. Therefore, my Lord, all these decisions which have been cited before your Lordship for the purpose of payment of occupation charge, I say I am not obliged to pay any occupation charge to anybody because I am the owner. If anybody, my Lord, is in occupation, he should pay to me. I am not going to pay to anybody else. This is the bold stand that I have taken in this. My Lord, then your Lordship will please to come to kindly see para 36. I am not going to read it out, but the plaintiff's right to raise the plea of adverse possession has been recognized in several decisions of the High Court also. And my Lord, the decisions have been referred to.
This is which paragraph?
My Lord, this is, my Lord, paragraph 36 at
Right.
page 768.
Yes.
And my Lord, this your Lordship also find that quite a few Calcutta decisions are there. Old Calcutta decision, 1919, 1916 Calcutta decision, 1917. And apart from it, my Lord, Madras is there, Lahore is there, Nagpur is there, Privy Council is there. My Lord, then kindly come to your Lordship will please to come to, I am not going to trouble your Lordship with a discussion of various judgment. Kindly come to para 52 at page 775. Under Article 64, that's of the Limitation Act, also suit can be filed based on possessory title. Law never intends a person who has perfected title to be deprived of filing suit under Article 65 to recover possession and to render him remediless. In case of infringement of any other right attracting any other article, such as in the case of the land is sold away by the owner after the extinguishment of his title, the suit can be filed by a person who has perfected his title by adverse possession to question the alienation and attempted dispossession. This is, my Lord, addressed to Money Square. That after I have acquired title, if the title is transferred to somebody else by the erstwhile owner, then, my Lord, the new owner cannot, my Lord, disturb my title. Then, my Lord, para 53, law of adverse possession does not qualify only a defendant for the acquisition of titles by way of adverse possession. It may be perfected by a person who is filing a suit. It only restricts a right of the owner to recover possession before the period of limitation fixed for the extinction of his rights expires. Once the right is extinguished, another person acquires prescriptive right which cannot be defeated by re-entry by the owner or subsequent acknowledgement of his rights. In such case, suit can be filed by the person whose right is sought to be defeated. In India, the law respects possession. Persons are not permitted to take law in their hands and dispossess a person in possession by force as observed in so and so by this court. The suit can be filed only based upon possessory title for appropriate relief under the Specific Relief Act by a person in possession. Under Article 64 and 65, both are attracted in such cases as held by this court in, my Lord, Desraj versus Bhagatram. That is reported in 2007-9 Supreme Court cases. In Naya Services Society, it was held that if the rightful owner does not commence an action to take possession within the period of limitation, his rights are lost and the person in possession acquires an absolute title. Then para 56. There is the acquisition of title in favor of the plaintiff, though it is negative negative conferral of right on extinguishment of the right of an owner of the property. It's a negative conferral of right. The right ripened by prescription by his adverse possession is absolute, and on disposition, he can sue based on title as envisaged and in the opening part of Article 65 of the Act. Under Article 65, the suit can be filed based on title for recovery of possession within 12 years of the start of adverse possession, if any, set up by the defendant. Otherwise, right to recover possession based on title is absolute, irrespective of limitation in the absence of adverse possession by the defendant in 12 years. The possession as trespasser is not adverse, nor long possession is synonymous with adverse possession. In other words, what it says is this: by reason of, my lord, adverse possession, a trespasser becomes the rightful owner. And then, my lord, he can, my lord, claim his title against the whole world only by reason of his possession. Continuous possession. Para 58, my lord, this is summary. We are not inclined to accept the submission that there is no conferral of right by adverse possession. Section 27 of the Limitation Act provides for extinguishment of right on the lapse of limitation fixed to institute a suit for possession of any property. The right to such property shall stand extinguished. The concept of adverse possession as evolved goes beyond it. On completion of a period and extinguishment of right, confers the same right on the possessor which has been extinguished, and not more than that. For a person to sue for possession would indicate the right has accrued to him in present time to obtain it, not in future. Any property in section 27 would include corporeal or incorporeal property. Article 65 deals with immovable property. Possession is the root of title and is the right like the property. As ownership is also of different kinds, namely sole ownership, contingent ownership, corporeal ownership, and legal equitable ownership. Limited ownership or limited rights to property may be enjoyed by a holder. What can be prescribable against is limited to the rights of the holder. Possession confers enforceable right under Section 6 of the Specific Relief Act. It has to be looked into what kind of possession is enjoyed, etc. Therefore, I am relying upon this judgment for the purpose of making this submission of mine, that if I am the owner of the property, because that is subject to the decision in the suit which I have filed. If I am the owner of the property, then nobody can claim any charge from me. I am distinguishing all these decisions which have been cited, relied upon by my learned friend, by saying that these are all the properties which belong to X, and Y is in possession. A decree has been passed in all the cases, excepting, my lord, the last Manish Kumar's case. I will submit to your lordship, Manish Kumar's case is, my lord, is the Supreme Court's exercise of power under Article 142. Because it is inconsistent with, if I may use that expression, from all the other decisions, Atmaram's case, Martin Harris' case, the other is the Achal Kumar's case. All these decisions, my lord, have been considered in that. In each and every case, a decree for possession was passed. That the lease came to an end. The possession of the person who was, my lord, in possession of the property had become precarious. So the court says that if after a decree you want to enjoy the property, you must pay for it. And the court had fixed the mean profit or occupation charge for that. But I will respectfully submit to your lordship that I stand on a different platform altogether. I am saying I am not, my lord, I am not accountable to anybody for possession of this property or to pay to anybody. On what right Money Square will pay? The Money Square's title is, my lord, acquired from the owner. If I succeed in my suit, then I become the owner. Money Square becomes the trespasser. Therefore, my lord, kindly, my lord, look at it from that point of view. I am making this distinction between all these decisions cited and my decision.
When did you file your suit?
I filed my 2023.
Have you filed any application for interlocutory relief? Any kind of relief? No. Injunction against dispossession or something to that effect?
No. Interlocutory. No, my lord. We have not filed any application for interlocutory relief. We have filed an application under Order 7 Rule 11, which is not for interlocutory relief.
That is in their suit.
Yeah. No, in my suit also there is an application.
They have filed.
They have filed Order 7 Rule 11.
That's right.
Yes.
That's right.
Now, my lord, this is one part of my submission, and my lord, I shall just be very short. Insofar as Section 12A is concerned, my lord, it has been submitted by Mr. Kaur, but perhaps he may not be quite right. My lord, no decision has been made either by my lord the learned trial judge here or by the Supreme Court on 12A. My lord, the submission was made that as if 12A Section 12A application had been disposed of by reason of the judgments. I will request your lordship to look into these two judgments of both of the trial court as also the Supreme Court. There is not a whisper of 12A. 12A has not been considered as yet, and that was our grievance. We said that Section 12, without considering Section 12A, how are you considering the interlocutory application? My application.
12A was one of the grounds in the SLP that was pointed out. Also a question of law. It's your SLP, which was dismissed. So,
But all questions were left open by the Supreme Court.
civil revision also, yes.
Can we see the Supreme Court judgment? The order in that? Well, this has been handed over to your lordship. Well, this is
in the civil revisional application squarely this was mentioned by the learned judge.
But then, my lord, the learned judge mentioned it and my lord passed it on.
Deemed to have been rejected.
But there is, I will submit to your lordship, this is not a matter which can be deemed to have been rejected. Your lordship sees the language of the section. But your lordship kindly see, there is no mention of actual adjudication on that issue. My lord, kindly see, act. Well, I will submit to your lordship, but this is of course, this is something, my lord, it is akin to Section 80 of the Civil Procedure Code. Lordship sees the Section 12A language is such, one can't just say that I have mentioned that therefore adjudication has been made. Pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted. Well, it goes to the institution of the suit. Unless the plaintiff exhausts his remedy of pre-institution mediation. Therefore, a suit, kindly see double negative. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted. There are two nots in this. It's a complete embargo. So, one has to apply Bosho. So, one has to apply one's mind, consider as to whether it, my lord, contemplates any urgent relief. And then only, my lord, the court can come to a conclusion. One has to have an adjudication on this issue. There has been no adjudication at all. I say that without any fear of contradiction. Excepting for in passing Section 12A application has been. Otherwise, my lord, this matter, my lord, because my application is pending. Not only my application is pending, I have made two other applications for, my lord, early hearing. And my lord, we took the point before the learned interlocutory judge in the trial court. We said that, look, why should you hear this matter when my Section 12A application is pending? Hear out my application first before you hear this. But that was not accidental.
In your Order 7 Rule 11 application, that probably traveled all the way to the Supreme Court. This was not one of the grounds for rejection of the plaint?
Yes.
What was the ground?
Possibly it was.
He said that this has been granted, wrongly granted. This was not the ground under Order 7 Rule 11. Cause of action,
But so far as I recall, it was the application was on the basis of the cause of action and limitation.
Point taken that 12A was granted.
We have a copy of that application,
Yes, we have got a copy of the application. I think it is there. I have seen it.
It was granted.
ওটা দাও না আমাকে, এটা দাও, এটা অ্যানেক্স করা রয়েছে। Kindly give me 1 second, but I think it is there. Volume 1 টা দেখো তো। Volume 1 টা কোথায় গেল আমার? Give me 1 second. So much of paper. দেখো, এটা আমাদের অ্যানেক্স করেননি?
তোমার কাছে আছে কালকে তোমাকে বোধহয় ওরা দিয়েছে
না না, আমার কাছে আছে, আমি দেখেছি, মার্ক করেছি। মার্ক করে দেবো? না, মার্ক করেছি আমি, দেখো না। হ্যাঁ,
বলেছেন বলে
দেখো জজ পেল। আমাকে একটা কপি দাও।
mention affidavit এই প্যারাগ্রাফটা আছে it's there in the supplementary sir. একবার স্যারকে দেখিয়ে নিই
Well, I must also tell your lordship that a supplementary affidavit, there, my lord, it's in the main petition, my lord, there are two grounds, cause of action and limitation. But my lord, in the supplementary affidavit,
আমি দিচ্ছি স্যার একটু দেখে নিন তারপর
my lord, paragraph 4 in this, my lord, I've said that
just a recording of fact this was not
and this was not discussed or, my lord, adjudicated upon.
but kindly একটু একটা কথা
কোথায় একটা কথা? তারপরে আমি hand up. But in supplementary affidavit we have filed, I must frankly tell your lordship, paragraph 4. But this was not discussed. This was not, my lord, adjudicated upon at all. This is the point. We have said that without prejudice to the aforesaid, even assuming, though not admitting the incident dispute to be a commercial dispute, even then the plaintiffs have not complied with section 12A of the Commercial Codes Act prior to incident, and as such the incident suit is premature. This point had not been considered. Trial court order ইয়েতে কোথায় রয়েছে? এগুলো হ্যান্ড আপ করে এগুলো কপি রয়েছে নিশ্চয়ই, এখানে অ্যানেক্স করা রয়েছে।
Because may we hand over the copy of the supplementary affidavit?
I have
Hand it over.
They have given us. They have given us one copy. We need a.
We have two copies. Paragraph 4 of that, we have said so.
discussion of the trial
এটা কবে তার অর্ডারটা? পেজ 175, এটাই তো, মানে পেজ 175 is the order of the trial court. There is not a no discussion on that. Subject to correction by my learned friend if I've missed something. It's a longish order. I could not find anything. A lot of things have been discussed excepting that. But this is the judgment is at page 175 of volume 2. Volume 2 of this paper book.
কম্পাইলেশন আছে তোমার একটা কম্পাইলেশন আছে
না, ওরা দিয়েছে, আমাকে দেয়নি।
তুমি নোট করেছো, নোট করলে কালকে
আমার কাছে কম্পাইলেশন
what সেটা জজকে
175 is the order impugned in this appeal, isn't it?
কোনটা থেকে দেখাচ্ছে সেটা
well this এটা কোন অ্যাপিল থেকে
দেখাচ্ছে
AO নাম্বার কমার্শিয়াল
এই লিস্ট অফ ডেটস দাও না।
ভলিউম
দেখো
Trial 6th March 24.
6th March
কোথায়?
24. Lordship kindly give
Where is it? Where is it? In the no 175 is 22nd July order.
This 26th July. No, no, it was. I'm getting utterly confused. এটা কি?
এই অর্ডারটাই this is the order. That's the order.
But this is not the order passed in order 7 rule 11.
No, order says
6th of March এর এই অর্ডারটা কপি নেই এখানে মানে অ্যানেক্স করা নেই।
It's not there in the on record. I see. 22nd July is order 39 rule 1 and 2 read
Yes.
with 151.
Yes,
So we should give us
absolutely. হ্যাঁ তারপরে কি হলো? কার কাছে? কোন প্যারাগ্রাফটা বলো? তুমি কোথায় বলেছো?
7. So it's nothing on 12. এখানে একটা জায়গায় লিখেছে that they had applied for no applied for 12. সেইটা লিখেছে ফলদার আর্গুমেন্ট।
আমাকে একটা কপি দাও না, জাজমেন্টের কপিটা দাও তাহলে আমি বার করতে পারি। জাজমেন্টের কপি দাও।
Hmm.
আমার এই বই হয়ে গেছে, এই প্যারাগ্রাফ গুলো বার করছি। এটাই সম্ভব।
প্যারাগ্রাফ 70 স্যার দেখিয়েছিল 17 adjudicated upon 12.
Your lordship is looking into
The order
of justice.
dismissing no trial court's order dismissing your order 7 rule 11.
Yes, my lord, there have been no. There is. I must tell your lordship, my lord, where it has been mentioned. Before Justice Sarkar, my lord, it has been mentioned. Kindly take the judgment of Justice Sarkar, which is, my lord, dated 21st May 24.
কত কথা? Page.
No, এটা কোন
Please,
এগুলো annex করনি আমরা কোন
Page 3.
No, no, it has been handed
No,
up
no,
to your
no.
lordship.
This is not, it's shortcut order.
আলাদা আছে?
It's not a part of it.
আচ্ছা।
Separately handled.
Your lordship has got the copy of the
Copy
judgment.
supplied, correct.
Was it Justice Sarkar?
এই দেখো না বাবা, জাস্টিস সম্পাসকের আলাদা করে দিয়েছিলেন
It was handed up by Mr.
just now.
No, 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 no.
তার আগে দেওয়া হয়েছে।
No, no, it was given last on the
Judgment
last day.
দিয়েছে, জানি জয়দীপ দিয়েছে মনে হয়। এটা ডেট হচ্ছে
CO 954, 21st May.
21st May. আর একটা কপি নেই just. Your lordship kindly comes to paragraph 7. The petitioners also raised a question with regard to maintainability of the suit in commercial court on account of non-compliance of section 12A of the Commercial Courts Act. It was submitted that mediation had not been initiated by the plaintiff opposite party. And then, my lord, the only discussion subject to correction by my learned friend is para 17. The only mention, not discussion. It is only mention, para 17 at page 10. The plaintiff discloses a cause of action for suing the defendant. The reliefs are in consonance with the cause of action, namely recovery of possession, mean profits, etc. The calculation of the mean profits have been provided in the plain. There are averments with regard to valuation. The leave under clause 12A was paid for and was allowed by the court. The pleading that the suit was not barred by limitation is available in para 36. It was stated the cause of action arose upon disposal of the appeal by the apex court in July 2022, and no part of the claim could be treated as barred. The Honorable Apex Court had permitted the opposite party to proceed against the petitioner in accordance with law. Upon holding that the petitioner were not thika tenants, the fact that property had been used for commercial activity has been stated in the plaint. That's all that has been stated. My lord, it has not been discussed. It has not been. My lord, our contention was this, that more than 6 months after the Supreme Court judgment, had the suit been filed, there was no reason as to why this particular period could not have been, my lord, utilized for the purpose of compliance with section 12A. And my lord, this was the contention we had raised in section 12A. I would have understood, my lord, if my application had been dismissed, then I could have had appeal to I could have gone up in the higher court. But my lord, this issue had been kept pending. The application is still pending, and my lord, this is, my lord, rotating in the registry. Once it is coming up before the court, again going down. And my lord, my last application was, my lord, for transfer. I said that if you can't hear it, transfer it before some other court.
Against this you went up.
Yes.
Where is that Supreme Court order? Separately.
10
September.
Compilation সব কিছু রয়েছে।
দেখো দেখো
তোমাদের কম্পাইলেশন নিয়ে কিন্তু আমি কপি পাইনি কম্পাইলেশন।
আমরা ইন্ডিভিজুয়ালি অর্ডার হিসেবে
আমাদের লাস্ট লাইন অফ দ্যাট
an order dated 14th of July 2024.
Huh?
10 September.
Special leave? Dismiss? 10 September. 10 September. 10 September 24. I'm sorry. SLP was filed on 14th.
10 September order has been given to your lordship. Merit of the suit, thou বলেনি application. না সেটা বলছি না আমি তার কারণ actually it is pending.
Yes.
We are making application for early hearing. We have also made an application that before you hear the
Hear
email,
this?
no, you say, here, these are all on record.
All on.
তাহলে আর কি?
But the change at 12 is disposed of completely.
না না সেটা
Keeping my revocation.
সেটা বলছি
We have a question to both of you,
Yes.
or all of you. A relief claimed in a proceeding, if not granted, or even not expressly rejected, but not granted, is deemed to be rejected. Section 11 principle. Now let us say you have filed a suit. Mr. Kaur applies for rejection of the plaint on grounds A, B, C. The trial court does not discuss ground B at all. The next forum, next higher forum, revisional court, mentions ground B, but does not say whether she
is
accepts
adjudicating.
or rejects. Obviously, she has not accepted, because if she had accepted ground B, then the plaint would have been rejected. But she also does not say that she is rejecting, but she mentions.
Well, may I interject here with your lordship's leave? Here, it is quite possible that the learned judge found that the application for revocation is pending. That matter is not before her
It was
lordship.
not pending then. It was not pending.
Yes, it was. It is still pending.
At that time, it was not.
not pending.
Oh, I see. At that time, no. Section 12A.
No,
No.
revocation of section 12A leave specifically,
Yes.
which you have filed,
Yes.
that came later.
So therefore, my lord, the court did not have any occasion to either reject it or accept it. Let me put it that way.
The judge, revisional court, noted the ground,
Yes. Section
noted the ground,
section
did not accept the ground.
did not adjudicate on the ground. He did not. She did not.
This is what we want to know. And then the Supreme Court does not interfere.
Yes, Supreme Court does not interfere because Supreme Court says Order 7 Rule 11 application ground has not been made out. The learned trial judge had rightly rejected the application.
Devoid of merit, that is the
Yeah,
ground. Only says devoid of merit. SLP is devoid of merit.
Devoid of merit.
And we are not pronouncing on the merits of the suit.
Well, can I not submit this way?
No, we are asking, can it be argued by Mr. Kaur that having noted ground B, which is 12A ground, and not having accepted that, that issue is decided?
Well, 12,
Can it be argued?
well, I will submit to your lordship. Perhaps it cannot be argued for this reason that section 12A ground was not in the mind of the learned judge.
Not even taken.
How do we say that? Because the learned had noted that point.
Noted that, and then thereafter, my lord, not after all, Order 7 Rule 11 application has been decided on certain grounds. Section 12A ground was not one of the grounds. Let me put it this way.
Why shouldn't the same principle apply here? Unless allowed. Specific rejection of দরকার নেই। একেবারে মেনশনই করলো। That's a difference.
No, বলে তো লাভ নেই। বলতে যে তুমি একটা ফ্যাক্ট হিসেবে ট্রেড করছো।
Please help us on that.
I'll answer, Lord, when
Yes.
because I'll have to deal with this judgment. I'll just answer that.
So, my lord, I am submitting to your lordship that section 12A had not been decided, not been adjudicated, because, my lord, the court will have to apply its mind and will have to say that there is since no, it did not contemplate, my lord, it will have to say that it did not contemplate any urgent interim relief, and therefore it was not necessary to have section 12A leave, or section 12A leave is being granted because no urgent interim relief is being sought for. So, some pronouncement has to be made on this. But section 12A cannot be just bypassed, just by having it brushed aside. Well, because it says a suit which does not contemplate any urgent interim relief under this act. And particularly when by the time the matter came up for hearing, my lord, ultimately, my lord, an application was made was kept pending on this. Maybe it is quite possible that at that particular point of time, when, my lord, the matter was heard, only it was in passing mentioned section 12A. I am, my lord, arguing against myself. Maybe it was not seriously contended at that stage. It is quite possible. But, my lord, since it was not seriously contended at that point of time, not having been taken expressly, my lord, by way of an application, perhaps the court said that I don't have to go into that issue. Perhaps that will be the correct interpretation. It is not that I have taken the point.
You have a copy of the revisional application.
Revisional application.
Revisional application. Huh.
My lord, will your lordship allow me to chat because I was not there at all. I am here for the first time.
We would like to have a look at the revisional application.
না তুমি বলো জজ সাহেবকে বলো আমার
If you want a date for that, we are willing to give you a date.
তুমি কি রিভিশনাল অ্যাপ্লিকেশন তোমাদের কখন এটা তুমি কখন বার করতে পারবে? Shall I look into it and come before lordship?
Yes.
Because I will try and assist your lordship to the best possible.
Yes, yes. Please, both of you do that.
Anyway, my lord, if I have made this contention and that has been rejected, then, my lord, I shall accept it. I will not, my lord, try and miss.
And also a point of law, as we mentioned, like a deemed rejection of a relief claimed, can there be a deemed rejection of a ground in support of the relief?
Very well, I shall look it up.
But incidentally, the judgment that has been handed up to your lordship by Mr. Mitro,
Yes.
kindly come to paragraph 85. Lord, in fact, ironically, Lord, I was relying on this judgment in the application filed under Order 7, Rule 11 before the commercial court. Please come to paragraph 85.
Paragraph 85.
There is no paragraph 85.
No, Lord, this is that Yashwant.
Oh no, Ravindra.
Sorry. This is,
কোথায় গেল ওর 19 জাজমেন্টটা?
Lord, in fact, sorry, Lord, this is a subsequent judgment to this 2019, which has been cited. This is in Yashwant Sinha versus CVI. Lord, where, Lord, this judgment has been considered. No, I'm sorry, I got mixed up. I'm
This
sorry.
is not the one.
Paragraph 85 to 87. If
No,
you
what Mr. Kaur is saying, the one you cited has been dealt with by a
By the
subsequent.
judgment, but I did not.
paragraph 85 to 87, if your lordship's Lord, kindly have a look at.
They have cited in this proceeding, Order 7 Rule 11 or Adjudication.
Kindly, Lord, come to paragraph 85. This is only on the question that this court framed, Lord, my lord asked. Where a party institute a proceedings, if it's proceedings of a civil nature, there would be a cause of action. Paragraph 85.
Yes.
There would be reliefs sought on the basis of the cause of action. Materials are produced both in support and against the claim. The court thereafter renders a judgment either accepting the case or rejecting the case. When the court rejects the case, it necessarily involves refusing the grant of relief sought for by the plaintiff petitioner. It may transpire that the petitioner may not press for certain reliefs. The court may, after applying its mind to the case, find that the petitioner is not entitled to the relief and decline the prayer sought. It may also happen that the court does refer to the relief sought, but thereafter does not undertake any discussion regarding the case for relief sought and proceeds to non-suit the party. It is clear that in this case, it is the last aspect which is revealed by the judgment sought to be reviewed. Then, Lord, please come to 86. A judgment may be silent in regard to a relief which is sought by party. It is opposite in this regard to notice under section 11 CPC if a decree is silent as regards any relief which is claimed by the plaintiff. Explanation 5 to section 11 declares that the relief must be treated as declined. Then, Lord, explanation 5 is quoted. And then, Lord, paragraph 87, it says that when there is an expressly refuse, that's one thing. But there can be an implied refusal when the court in silent does not deal with the point. This is, Lord, because your lordships will find in the SLP, specific grounds were taken But if they have not pressed that ground before the Supreme Court, that is also end of it. That brings an finality to the issue. And the other thing is paragraph 60 of this judgment also, and paragraph 60 of the other judgment which Mr. Mitro has cited. Kindly have a look at what are the three ingredients of an adverse title. Kindly see paragraph 60
Of
Mr. Mitro's judgment or this judgment. They are copy, in fact. Kindly come to paragraph 60 of Mr. Mitro's judgment. Mr. Mitro cited. Paragraph 60, if your lordship kindly have it.
yes.
The adverse possession requires all the three classic requirements to coexist at the same time, namely adequate in continuity, adequate in publicity, adverse to a competitor in denial of title and his knowledge. Now, my lord, kindly have a look at my list of dates. Your lordships will find from 93 onwards, his claim was that I am a thika tenant. No title was claimed in adverse to the title of the original owners. And Lord, the tussle of title was between my clients and the state. Because, Lord, the property having vested in the state, I was contending that there has been no vesting because thika tenancy does not apply. That was the tussle which came to an end, Lord, in 2022. So, Lord, prior to 2019, between 1993 and 2003, when he filed the Form A, accepting his status as a thika tenant, he has never, Lord, alleged any adverse title or, Lord, asserted any adverse title in regard to the property. And this is our argument in Order 7, Rule 11, which is, Lord, being heard. I am at the reply stage before the commercial court. And in fact,
March 2014 Division.
That is all then. We need not look into the
Division
revision.
bench also has dealt with this issue. His status as thika tenant, since when he has asserted his right.
Bhattacharya.
Justice Bhattacharya. I'll just read it out. Lord, one paragraph, I'll just read it out. Admittedly, the lessees, namely private respondents, paid rent to then landlord up to 93. And they never claimed themselves as thika tenant under their landlord till 9th April 2003. It is only after 2001 Act came into operation that said lessees submitted return before the controller on 10th April 2003, claiming themselves as thika tenants in respect of the said premises and deposited rent with interest with the controller for the period 18 January 82 till 2007 at a time in 2007. This is not in the at page 4. আছে বলতে ওটা জজ সাহেবের কাছে আছে আর দিও না
কি তাহলে আগে দিয়ে আবার দিচ্ছ কাজ
page 4 of the division bench judgment. Lord, I can mark the paragraph if your lordship permits. I can just, Lord, by pencil I'll mark it in your lordship's copy. Page 4, that paragraph is there. So, Lord, these three tests is being applied by the commercial court in, Lord, considering my application under Order 7, Rule 11.
That is all.
May I just react to this short sentence? Well, my respectful submission is what my learned friend showed to your lordship that in 1993 up to 2006, my lord, thika tenancy was not claimed. Thika tenancy was claimed in 2006.
2003 you filed the form. Form A.
Yes.
So that's 10 years.
Yes. But ultimately, it was adjudicated that I was not a thika tenant.
In 2022, finally.
When my lord, it was adjudicated that I was not a thika tenant, then, my lord, I was a trespasser throughout adjudication. I am saying that whatever my contention is, By adjudication, I was found to be not a tika tenant, not a tenant, not a lessee,
In unlawful occupation, let us say.
unlawful occupation.
But would that be necessarily adverse? That's the question.
My submission is this:
Right,
if my lord, the owner of the property, because when did my lord Money Square purchase the property? Kindly see the date. By that time, I have already become the. My lord, become the. Title has been perfected in my favor, and that is my contention, and that is the subject matter of the suit. The suit is not to be prejudged now. Therefore, my lord, I submit to your lordship that insofar as this judgment is concerned, well, the judgment which has just now been cited by my learned friend, lordship will please to see that paragraph 86 says, kindly see, this is on the issue of res judicata. This, my lord, this judgment does not say anything with regard to sub silentio if, my lord, the issue is not discussed at all. It is res judicata explanation 5 is any relief claimed in the plain which is not expressly granted by the decree shall for the purpose of this section be deemed to have been refused. Well, in interpreting this particular explanation, the court says that a judgment may be silent in regard to the relief which is sought to be claimed by a party. Well, if a relief is being claimed and with regard to it is not being granted, then, my lord, sub silentio by reason of the explanation, it will be deemed to have been rejected. And, my lord, this is the way how, my lord, constructive res judicata, my lord, is held. My lord, as against, my lord, res judicata, paragraph 87, constructive res judicata is explanation 5. So, my lord, I have claimed a relief, it has not been granted. I have not claimed relief. My lord, nobody has said that my Order 7 Rule 11 application contains any averment with regard to non-compliance of Section 12. It is only with regard to limitation and cause of action.
Justice Sarkar has noted.
Just noted. And, my lord, just passed on. Paragraph 7, paragraph 17. These are my respectful submission. Well, I cannot put my case higher than that.
এটা নিয়েছিলেন স্যার অর্ডার 7 রুল 11 গ্রাউন্ডটা নিয়েছিলেন
না ওটা দেখানো হয়েছে
বাই সাপ্লিমেন্টারি অ্যাফিডেভিট নেওয়া হচ্ছে
আমি সাপ্লিমেন্ট
But the learned trial court doesn't refer to it at all.
did not but this point was taken as a ground in the 227 and therefore the court
was never a ground
and it was argued recorded.
That is all then? We'll reserve order?
আর কিছু বলবেন
ইস্যুটা হচ্ছে রেভোকেশন
ঠিক আছে রেভোকেশনের
আচ্ছা
বলেন।
ঠিক আছে হয়ে গেছে
Hearing is concluded. Judgment is. আমার কাছে পাঠিয়ে দাও।
Yes, my lord, the only other thing is this: in the other judgments, my lord, there are factual finding with regard to the amount of money which is being withdrawn from the property. In our case, my lord, there is no evidence that any amount is being the amount which is so yes, it is not being used commercially, and by reason of the order of injunction, I cannot, my lord, induct anybody on the property. That property is lying fallow. At the moment, the property is lying fallow.
So that
No
It has become a liability then to you.
in a way.
Why keep it?
ওনার হবে এক সময়
the liability হলে ওনার হয়ে কি হবে
তখন তো লাইবিলিটি থাকবে
না ওইগুলো গুছিয়ে পাঠিয়ে দাও লুজ গুলো সব আলাদা করে একটা ফাইলে দেবে সেগুলো হ্যাঁ
extremely grateful to
আমার নোটটা উপরে রাখো ছোট্ট তো খুঁজে পাবো না
my lord, have I handed over to your lordship, my lord, the final order in Manish Kumar's judgment on which, my lord, strong reliance had been placed. Finally, my lord, the matter had been posed.
That was an interim order.
that was an interim order pending final disposal এটাতেও হবে ওই এই অর্ডারটা হলেই হয়ে যাবে
ওটা দাও না কথা
এই অর্ডারটা সাসপেন্ড হলেই হয়ে যাবে much of that
ঠান্ডা লেগেছে জ্বর
তাহলে এটা আমার
এটা
এটা নিয়ে নাও।
Mr. Kormakar had informed your lordship here that
Yes, 4 dates we had suggested. So either 3rd or 4th of September.
told to several things. And third, your lordship has probably 28th, 3rd, and 4th.
So either 3rd or 4th, let me talk to my sister and we will let you know well in advance.
I had some little date because I sent Mr. Kormakar.
Mr. Chaudhary has completed.
So yes, you are making a sum.
You are making submission. How long should you take?
Half an hour to
Not more than. So if one day we sit at 3 o'clock,
finish.
including reply.
And if it's not a right,
No, it won't be. 3rd and 4th is not a right.
not a right, there's no problem. Because now I hear the consensus is that 3:30s would happen only on Friday.
Or if Friday is a holiday, then Thursday. 4th is a Thursday and 5th is a holiday. So 3rd we'll try to sit. 3rd we'll try to see. বুঝেছো? মনে করবে 3rd. 28 তো হতে পারে, আমার কি প্রবলেম?
28 would be not, at least we can start and finish. So we have
অন্য কিছু আছে কিনা দেখো আগে। 28 কিছু নেই। তা তুমি চেম্বারে আসবে যখন বলবে আগে 28টা দেখবো। Mr. Chaudhary will be back. You understand he's not in town.
traveling, but he should be back by 26th.
28th is all right with him.
With him, it's all right. Item 3.
This is that Malad hotel matter. Malad.
I'm for the response.
Yes. Mr. Bachawat was arguing.
Malad, we were placing Malad the Nirula's judgment of the Delhi High Court
2008.
Malad by Justice Bhatt Malad, as his lordship then was before the Honorable Delhi High Court. Malad, kindly have a look at this judgment, Malad. A similar issue, my lord, had cropped up in this case also. Your lordship takes from my lord, paragraph 3 onwards. My lord, here also, my lord, in fact, paragraph 2, according to the plain governments, plaintiff is copyright holder of a variety of literary and musical works, sound recordings, music videos, and cinematographic videos.
Mr. Rajudri, the entire judgment was placed.
The entirety, very well, my lord. If your lordship, my
At
lord,
least till
in-
17.
Yes.
Till 17.
till 17.
Huh.
My lord, I think till 18, but I'll place 18, my lord, also.
Yes.
Kindly have a look at my lord 18. The expansive definition under section 2FF in this case would mean that broadcast is deemed to be communication to the public. The question is, what is copyright deemed infringed? As noticed earlier, the plaintiff claims copyright in the music recordings as well as the video recordings. The objection that the plaintiff has not disclosed whether and to what extent it parted with any of those rights to the broadcaster cannot really be gone into. The plaintiff has in any case asserted these rights under section 51 small Roman 2. Infringement occurs if anyone permits for profit any place to be used for the communication of the work to the public where such communication constitutes an infringement of the copyright in the work, unless he was not aware and had no reasonable ground for believing that such communication to the public would be an infringement of copyright. The exception to this definition of infringement is contained in section 52. In terms of section 52 1K, the causing of a recording to be heard in an enclosed room or hall meant for the common use of residents in any residential premises. Now, if your lordship sees the bracketed portion, not being a hotel or similar commercial establishment. So, my lord, hotels has been categorically excluded. And what my learned friend runs is a hotel. My lord, sees from the even cost title, it is Hotel Apollo. as part of the amenities provided exclusively or mainly for residents therein is not deemed to be an infringement. So, my lord, they don't come under this exception because they are a hotel. Kindly see this 52(1)(k). Similarly, an exception involving the communication of a work, the public, of a sound recording in the course of any bona fide religious ceremony is not a public performance. These are the exceptions under the Copyright Act, that what would not be an infringement. So, my lord, private use inside your house, not an infringement. Then, my lord, for a religious ceremony, not an infringement. So, my lord, rest everything becomes infringement under the law. Then, my lord, kindly see similar and involving communication of a work to the public in the course of any bona fide religious ceremony. These provisions are pointers to the legislative intent of treating use of televisions and sound recordings in hotels as communication to the public. The intention appears to be reinforced by specific exception from section 52 of the category of what is not infringement, the use of recording to be heard in a hotel. So, my lord, kindly permits, my lord, I'm being led by Mr. Pachal.
I'm sorry. When is placing this judgment?
No. Paragraph 18 was placed by Chief Judge.
But there's been a little gap in between. Not just not want to show your lordship the rest of the judgment which was shown earlier, because those are the arguments which he will make, and those are taken care of in the judgment. For that, may I just take your lordship very quickly through the same judgment, the earlier parts, unless your lordships remember.
We do. We have
Your
marked
lordship.
it extensively.
Then I won't trouble your lordship. Then I will not. There are 4 arguments made which are recorded, which my learned friend will perhaps make, including not this exact same case. The argument made is that, look, a broadcaster is someone else. He has the right. He is giving it to me. If he is authorized to give it to me, then my giving it to my consumer in the hotel is not an infringement. This is not the argument which was made there. Not 4 arguments, if your lordship only just sees that very briefly, not at para 9. Para 9. Mr. Mudit Sharma, learned counsel, submits that through the affidavit of the investigator, plaintiff has admitted that content was being provided by the cable operator through various channels and not by the defendant. So this is defense number 1. Then we'll not go down about 8 lines more. Not a sentence beginning with, if the broadcast itself was not illegal. So not if what the cable network provider is giving is not illegal. If the broadcast itself was not illegal, he contended that the broadcaster would be entitled to broadcast reproduction right under section 37, which allows the broadcaster to communicate the work to the public. So, if what that gentleman is giving, not the cable provider is giving, is legal, then providing it further in the hotel will not be illegal. This is the second argument. The broadcast itself and receiving of such broadcast he submitted would not be an infringement. Then, third argument. He submitted that the defendant was merely receiving the signals transmitted by the cable operator. And because the plaintiff does not dispute the legality of the cable operator's content, the defendant itself could not be held to be liable for infringement. So that's the third argument. Para 10 is the last one. Counsel for the defendant next submitted that the plaintiff has no locus standi to file such a suit as an independent copyright of the broadcaster subsists in the broadcast, and the latter is the owner of the copyright. So these are the 4 arguments which are considered here and rejected. But my learned friend has showed your lordship the other paras. I'll just trouble your lordship with the remaining paras. Not 19 or dekhi diye to. Oh, not if I may just place para 19 and not hoega. But then if your lordship can come straight away to the operative portion, if your lordship comes to para 22, the plaintiff has been able to show that the defendants are using cable connection and extending facilities of television to their patrons in the hotel rooms. 4 payments are received. In this view, prima facie content of songs and videos broadcast are communications to the public. Defendant's contention that the plaintiff has not said it was not licensed any right to the broadcaster as a matter of defense. The extent of the license, if any, and the terms of the license are matters which have to be gone into at trial. Plaintiff's right to the titles and video recordings as owners of the copyright is alleged. There is material on record to substantiate it. Defendant is a hotel. In the circumstances, plaintiff has established a strong prima facie case, balance of convenience in its favor.
since refusal to confirm the injunction would mean that the defendant is free to continue infringing the copyright, and my lord, the injunction is confirmed. So, my lord, here the facts are identical. The only difference was, my lord, the owner of the right in that case was the owner of the cinema. That's the only difference. Rights are exactly the same. I've showed your lordship the provisions of the Copyright Act, my lord, that there are independent rights and each one has a right. So, my lord, facts are identical. Now, my lord, in addition to this, my lord, just to repeat, my lord, two sentences of what I said earlier, my lord, Copyright Act, my lord, creates ownership in property. It's a statutory right. But the owners of these rights in our case are the, my lord, music composers and, my lord, the lyricist. They have not given the right to IPRS, which is a statutorily protected and recognized body, recognized by the government of India. They have been given the right to collect on behalf of these owners of the copyright. Their right is also not fully recognized. There is no dispute and cannot be any dispute about that. Now, the only question is not whether a hotel is entitled to transmit in their rooms without payment of royalty to each of these other copyright owners. This is the question before your lordship. That question, in my humble submission, is now decided. There is nothing left to decide here. In addition, I pointed out that apart from the fact that under the section itself, no one has the right to display this without the owner of the copyright. I pointed out there are very limited exceptions to this, which has also been considered, not in this case, not section 52, not exceptions, where one can not use copyrighted material without payment of royalty. And not, as I was joking on the last day, those are not available to me because I will never get married again. So, this is the given situation. There are two other judgments I'll show your lordship on this point. When this act was amended to make clear that these are all separate copyrights and each one has an independent right.
We'll come back in 4 minutes.
What Put together.
Yes, Mr. Bachchan.
Lord, Lord, that judgment which I have cited before your lordship considers all the provisions relevant to this. This is number one. Number two, your lordship would have noticed, Lord, it notices, Lord, judgments across the world. And, Lord, the parity of provisions before cable broadcast came in, Lord, with regard to wireless. Your lordship will remember London hotel with a lounge. So, Lord, using radio broadcast. All this has been considered the law across Canada, Lord, New South Wales, Australia, England, all of it is considered. Lord, this seems to be the worldwide position. Also, although, Lord, statutes in different countries may be different, but the principle, Lord, that a hotel room is not private space, Lord, that is not across the Lord board across the world now. And Lord, a specific statutory provision has been made, Lord. The only exception is a private home, Lord, excluding a hotel room. So, Lord, a specific exclusion, Lord, hotel rooms will not get this, Lord, benefit.
And religious.
So, hotel room doesn't fall within, not the exception. But there are other exceptions also. If your lordship just wants to see, but if your lordship takes section 52, do the copy there.
Copyright Act.
Yes.
এখানে কোথায় আছে?
So, Lord, there are a number of exceptions given in the act, but this will not fall within any. So, Lord, it's not that, Lord, the owner of a copyright can claim for everything. So, Lord, for example, a library in a school or educational institution, Lord, their permission, Lord, is given.
Yes.
So, Lord, there are a number of exceptions. I'll not trouble your lordship. So, Lord, fair dealing is the real exception, Lord. That's what this, Lord, section 52 is about. Certain acts not to be an infringement. And, my lord, it lays down specifically.
Very long section.
Long section. But he doesn't fall within any of them. My lord, most of this, your lordship will find, is to do with educational purpose. Not, of course, some is interesting spin-offs your lordship will find. Yeah. Now, the interesting part here, my lord, for example, my lord, use of books in educational institutions, libraries, etc., Lord, is an exception. It's not an infringement. But, my lord, if your lordship remembers from college days, of course, that is no longer there. Lord, photocopies of entire books being made and circulated. Lord, expensive books, Samuelson, cost, Lord, 10,000 rupees or 15,000 rupees. Full photocopies sets were available at, Lord, 250 rupees. So, Lord, Delhi High Court has ruled on that, saying that, look, that's not permissible. That would be an infringement. So, even a college, Lord, if it, Lord, photocopies and gives it to its students, not the full book, that will not be permissible. So, Lord, all those loopholes have been plugged.
এই একবার পজ করতে পারো তো এটা লাইভ স্ট্রিমিংটা
we have all been guilty of some form of copyright infringement or the other. But in our younger days, we have all copied cassettes or CDs and heard it.
Correct.
Now, but just because we did it would not make it not lawful. But in fact, I remember one place, there was some kind of a convention on copyright violation, and I was asked to speak there. So the first few speakers who went in there, they were talking about that was to do with music piracy. They were all saying this is really illegal, they should be arrested, and there were people from the police and the entire lower judiciary also there. Justice Aniruddha Bose was also there. So both me and him were shocked to see the approach taken. Wherever you see a copy of a music cassette being made, arrest the man, seize the equipment, etc. So the learned judge told me, Ki bolche, why don't you say something about it? I said, you're the judge, the judges will listen to you. But anyway, I had gone up first. So I started giving them examples. I said, look, each of you people then are guilty of piracy. Which of you don't have children at home? All your children download music, movies. So you're also guilty of infringement. If the computer belongs to you, you are equally liable under the act. That kind of shocked them. But we've all been guilty of this. So now, the exceptions given in the act, I'll not take your lordship through all of it, but your lordship could see K, 52K. This is the only exception which may have been applicable, but that is taken out by the amendment. So 52K is the causing of a recording to be heard in public by utilizing it in an enclosed room or hall meant for common use of residents in any residential premises, not being a hotel or similar commercial establishment. So, my lord, if your lordship is in a building complex, may be permissible, but it can't be hotel or commercial purpose as part of the amenities provided exclusively or mainly for residents, or as part of activities of a club or similar organization which is not established or conducted for profit. So, my lord, this clearly takes him away from the protection under Section 52. He will not fall within the fair dealing exception. But these are all known as the fair dealing exception, Section 52. So, my lord, he falls foul any which way, and he can't fall within the exception. Now, my lord, there's one further judgment. There's only one other judgment which I'll show your lordship on this point. This is a division bench judgment of the Delhi High Court, which was considering these amendments to the Act. The Vairis was challenged, and by all the interested groups, and the Hotel Association, in particular. So, representing his interest, challenge made to these provisions in the Copyright Act. Now, IPRS was then directed to be added as a party. IPRS is my client. Now, the first para, your lordship will find that the writ is for striking down the sections are mentioned 2FF, 33(3), 34(3).
Filed by Federation of Hotels
and the petitioner there is the Federation of Hotels and Restaurants Association.
2FF.
So, representing similar interests. And your lordship has seen 2FF, the Vairis of which is challenged. If I may just place that again. Communication to public, that's the so that is what is also under challenge. If your lordship turns the page, your lordship will find in the second line of the second page, IPRS stands impleaded as respondent number 2. So we were impleaded along with PPL also. Then the prayer is set out just below that, WPC number 452, declare by an appropriate writ order of direction, Section 2FF 13, 33(3) and 34(3) be declared ultra vires. Then, my lord, if your lordship sees,
there's a prayer for withdrawal of your registration also.
Yes.
IPRS.
Yes. Yes. So, that was subject to a number of litigations because there was a point of time when a part of the music industry had tried to grab control of IPRS, adverse interests, There was litigation relating to that in Calcutta, Lord Barasat, everywhere. That got resolved not once they'd lost some proceedings. Then, Lord, if your Lordship comes to not the bottom of the page, the petitioner's not arguments are set out there. I won't trouble your Lordship with all of it. If your Lordship not goes to the bottom of the page. Not one is it's saying it's unregulated and licenses have been given to us without not us having a right. Then, my Lord, your Lordship goes to right to the bottom of the page, the last line. The grievance is that the Copyright Act does not stipulate the conditions on which the said societies, i.e., PPL and IPRS, can issue licenses. And most importantly, what is the fee to be charged in that context? It is also contended that inasmuch as the copyright societies perform functions as broadcasters of music throughout the country as well as overseas, their functioning is of public character. And, my Lord, at the bottom of that para, your Lordship will find a grievance is made, last 4 lines, made of the absence of conditions made for fixing rates for issuance of licenses. Hence, the argument goes that these sections are ultra vires. Then, my Lord, if your Lordship turns the page and comes to para 4. I see. Yeah, I think we can show that. Lord, sorry, Lord, if your Lordship is on para 3, about 10 lines from the bottom, one of the other arguments, my Lord, sentence beginning with Mr. Basin, emphasizes that there is no privity of contract between the hotels and restaurants on the one hand and IPRS and PPL on the other. This is for the reason that the hotel receives these programs via broadcaster or MSO or cable operator operating in that area. So the argument is, look, I'm getting it from someone else. You have no right to charge me. No further payments are postulated or should be permitted. It is exclusively the responsibility and liability of the cable operator to obtain requisite copyright licenses. So, my Lord, this is the other argument. If your Lordship then turns to para 4, another argument made is, look, why should I pay both PPL and IPRS? Para 4, the dialectic which has been drawn up on behalf of the petitioner is that the rights of authors, lyricists, and composers are extinguished or become fused with the rights of the owner of the sound recording. Hence, separate payments for these two categories ought not to be countenanced. So he says, look, IPRS has no right to claim payment. So these are all, my Lord, argued. Now, my Lord, if your Lordship then goes to para 6, owners of copyright are fully entitled to reap the rewards of their creativity and genius. In the present regime, Parliament has seen fit to place a few restraints on the enjoyment of owners' rights. However, since a party can invoke Section 31 for obtaining a compulsory license from the Register of Copyrights by approaching the Copyright Board, competing interests have been balanced by Parliament. So, my Lord, my right to, my Lord, collect, my Lord, goes. Then, my Lord, para 8. Lord, it says that there is no public element involved in it. Lord, that's para 8. There is a plethora of precedents on this aspect of the law that a more detailed analysis would lead to inordinate prolixity of the judgment, as we already noted above. Broadcast or dissemination of music to the public at large is neither a statutory responsibility nor a duty of public character. Copyright and Performing Society, IPRS, PPL are an amalgamation of conglomeration of individual owners who are fully entitled to claim the highest premium for enjoyment of the fruit of their labor or intellect, subject to any statutory restraints that may have been put. Then, my Lord, we'll skip the portions on alternative remedy. We are not concerned. And if your Lordship comes to para 12. Now, may not be relevant to us because there have been not statutory
You will take some time, Mr. Pachawat? It's not for anything else.
15 to 20 minutes.
No, then we'll stop because Mr. Kundu is waiting for his matter. Mr. Devashish Kundu. 12:15, we had fixed his matter.
No difficulty.
It'll stay in the list where it is.
I'll take
Take your time. We are not rushing you. Take your time. Lekho. Mr. Bachawat, learned senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph. Will it just continue? Paragraph lists the matter once again. Kalke date diya tha thak retaining its position. Tomorrow, very unlikely. Day after tomorrow? Yes, in all likelihood, Thursday. But let it be in the list.
If there's a collapse, I'll come and do it tomorrow also. No difficulty, not whenever. Great.
Actually, I am for DSDA led by Mr. Surojit Nath Mitro and Mr. Bihani Lordship. Let them conclude their argument today, Lordship. On next occasion, Mr. Nath Mitro will submit it.
Give us 2 minutes, Mr. Kundu. Yes.
The function of my lord senior counsel, all matters will be released till 1:15, my lord.
You will continue till recess? Release করে দাও recess অবধি।
Great for a deep dive.
Release করে দাও, চয়ন কোথায় যাবে বলে দাঁড়িয়ে আছে। He's got another matter in some other court. My lord. May I comment, my lord? Yes. My last two questions, my lord, shown your lordships the entirety of the award, which is passed by the London arbitrator, and I had also referred to pages 270 to 272, which contain the details or the relevant portions of the cross-examination of the respondent's witness. I'll not refer to that right now because it will be repetition once again, which has already been recorded by the London arbitrator in this award. Now I'll come straight away to page 405, which is part of the impugned judgment before your lordships under section 34. Page 405. Volume 2. Volume 2, page 405. এটা ধরে রাখো তুমি, এটা রাখছে না।
In fact, the judgment commences at page, my lord.
395.
This is the impugned judgment.
Commences at page 397.
395.
395, I'm sorry. First are some recording of facts and not several losses with that. Now, my lord, will come to the part which the court will not felt was necessary for the purpose of disposing of the section 34 application. But we will come to page 405 first. The court below was clearly aware of the fact that not section 34 appeal is not a regular appeal. It says that it's a appeal with a very limited scope. But you will see at pages 405 and 406, he goes to repeats that this is the findings of the requirements of the Act itself, as also the various findings of the Supreme Court, that a very limited jurisdiction not akin to a regular appeal, first appeal, is the hallmark of a section 34 Act. Now, my lord, having regard to that, it was expected that the arbitrator would go into the nitty-gritties of the matter on the basis of the findings of facts made by the learned arbitrator. But instead of doing that, now your lordship will see what really took place before the learned court below in 5 pages, in 3 pages of your lordship, page 407 until 409. 3 pages. My learned friend will read the findings, and then I'll address your lordship. 407, lordship will take up.
Lordship, page 407 from last paragraph, will kindly allows me to test. 407. On scrutiny of the report, when it starts, the paragraph starts. May I please? On scrutiny of the report, I find that the report does not contain any plot number or measurement whatsoever. It is apparent no picture has been submitted and no high tide line has been shown in the report. On further scrutiny, I find that no georeference map has been enclosed and that apart location of the disputed structure at the work site has not been shown. In sum, it appears to me that the report of local inspection does not reflect the actual state of affairs. I have gone through the orders of the Urban Development Department via memo number 2266T dated 17/12/2004 and 2778T dated 20/12/2004 issued by Joint Secretary to the Government of West Bengal Urban Development Department. It emerges from the orders that Executive Officer of DSA was directed to take every step to stop construction works duly taken up by the private contractors on the strength of the MOUs at different locations, including B7 sector of Digha immediately. Next, the copy of the letter dated J17011 of the Government of India, Ministry of Environment and Forest IA Division, addressed to the Chief Secretary, Government of West Bengal, is taken up for consideration. The letter makes it crystal clear that B7 sector B7 of Digha development area has been incorporated in Coastal Zone Management Plan of West Bengal, and it has been categorized as CRZ2. The resolution of the meeting of DSDA held on 24/2005 reveals that on that date, MOUs signed with private contractors was cancelled and work order issued to the contractors were withdrawn. It was also resolved further that construction of stall at the site was stopped immediately till the issuance of fresh order after taking due care of CRZ norms and other paraphernalia. It is apparent that the resolution was drawn on the basis of the copy of the order of the Ministry of Environment and Forest IA Division. The coastal regulation zone map Ramnagar 1 block, Purbo Medinipur district, West Bengal, based on CRZ notification 2011, Ministry of Environment and Forest, Government of India, is available in the record, and this CRZ map was also produced before the learned arbitrator. The map highlights that the area up to Digha Railway comes within CRZ 2. In page 19 of the award, the learned arbitrator has observed, under such situation, this tribunal, in absence of contrary evidence or material to such findings of the expert appointed commissioner, who is a government officer, has no reason to distrust or reject such report of the expert, but to accept the same. Such observation of the learned arbitrator being considered with reference to the documents discussed in the above paragraphs, I feel no hesitation to hold that the learned arbitrator has failed to appreciate those documents, namely orders of Urban Development Department, copy of the letter of Ministry of Environment and Forest IA Division addressed to the Chief Secretary, and CRZ map, and accepted the report of the appointed commissioner as sacrosanct for the purpose of allowing the claims put forward by the builders. In fact, such award is contrary to law and justice. That being so, it is concluded that the award is in conflict with public policy of India, and therefore such award is not tenable in the eye of law. As such, the award shall be set aside.
So, my lord, very cryptic finding. Number, the best part of the is 3 pages. The pages whereof the learned 34 court came to its conclusion. Number 1, my lord, that the report was not properly made. My lord, page 245 by the lordship, page 245, the report of the
Expert.
expert.
First volume. Well, that's volume 1. 245.
What you will see, the report contains the entire details which have been either by mistake or blindly that you have not been contemplated in the report. You also will see that the report at the pages, it contains photographs. The finding is no photographs were there. Number 1. Number 2, my lord, you also will see at page, my lord,
251.
251.
Postal
All
zone.
coastal erosion zone, everything is there. High tide line, low tide line, everything. Now, upon producing of this report, no sane person would come to a conclusion.
Arbitrator was কিন্তু এই রিপোর্টে তো কোনো ফটোগ্রাফের কথা বলছে না। ফটোগ্রাফ দেখে কি লাগে নাকি
work order করে দিয়েছিল।
November 2004.
Yes, Mr. Kumar. My lord, so therefore, I am joining issues with the findings of the section 34 that the report was incomplete. Number one. Lord, no reasonable person could come to such a finding, Lord, after going through the report. My lord, most important is this. Next part of the order which records that the letters which were referred to in the order at pages 308 and 9, there are two letters which he places immense reliance on. Allah will see both the letters. One is in the month of December 2024. I don't know what you know. দুটো পড়ে যাচ্ছে
405
বল না
408 page 408 December 17 December 2004 17 December 2004 একটা হচ্ছে 17 December একটা 20th December
17 December and 28 December. Now both these letters have been issued after the work order was granted and issued in favor of the appellant.
17th and 20th December. Where are those letters?
Those letters are not a part of the arbitral proceedings. Your Lordship will kindly record this thing. Nor are the part of the section 34 application also. For the first time in argument, without bringing those letters in evidence, in a section 34 application, this argument was made. And that too, Xerox copies were produced, not even the originals. Your Lordship will kindly record my submission. And I showed to your Lordship. So, my lord, the learned arbitrator had no occasion to go through the veracity of these two letters, and assuming the same to be correct also.
Yes.
Those letters, can you take the dates? Both are the month of November and December 2004.
Both are December.
December, sorry, I'm
17th December 20th December
I said correct. So both are in December. Well before, on 29th of November 2004, we were given the work order. So, work order was issued to us on 29th of November. Then there was this inter-department.
Yes.
Now, inter-departmental letters have been issued in the month of December, and we were permitted to undertake the work on and from 12th January 2005. And who was
Yes.
And who was instrumental in commencing the work? The assistant engineer of DHTA. Under his supervision, we commence work because everything had to be done under his supervision. The engineer and the assistant engineer. And for the first time on March 21st, na? চিঠিগুলি বন্ধ ফার্স্ট চিঠিটা বন্ধ করেছিল সেগুলি পড়ো না
কত 24th March 2005
24th March
2005
the work was suspended.
Work was suspended.
Yes.
Gotcha.
Yes.
Work was suspended. Therefore, a letter was written.
A suspension letter is dated. I mean,
No, 24th March 2005. Page 44.
44.
44.
Yes.
The grounds were, kindly come to page 44. Grounds were, page 44.
Volume 1. Oh, দিয়েছে। Yes.
First we'll see the two regions, local regions, my lord. One,
With this is first the sign of some discrepancies relating to the second paragraph. Some discrepancies relating to the selection of the builder contractor came to notice. Moreover, it was found that some proper permissions were not obtained from the Ministry of Environment, Government of India, and West Bengal Pollution Control Board as required under the rules. In view of the above,
question is, assuming that, and why should I assume? You will have to take into account that the government of West Bengal, DHTA, were well aware that P7 area fell within the CRZ area. Let's assume that it fell within the CRZ area. Then the question would squarely stare at their face as to how could they issue such a tender notice for construction. So, and all these letters of December 2004 are deliberately, I will say, I will emphasize the word deliberately, not been incorporated in the judgment of defense before the landed arbitral tribunal or in the section 34 application. It is for the first time was arguing and then filed by way of a supplement, by way of a notion argument. It was handed over to the learned court below. Now, your lordship, I'll invite your lordships to come to the finding of the learned section 34 application, in which he comes to a conclusion that the arbitrator was in possession of a map which was prepared by the GSI, which clearly showed that B7 area fell within the CRZ2 area. Now, in that context, may I invite your lordships to come to page 270. That is the cross-examination of the respondent's witness. There was sole witness of the respondent who was the 2 pages of cross-examination that the entire case will open.
Well, Lord, you will find in the middle of the page, Mr. Ghosh in cross-examination. But question 10 onwards, come to annexure X of your affidavit, whether this is the exact photocopy of the part of the drawing submitted today, said to have been prepared by GSI. The answer is no. Then we have to arbitrator who has prepared this annexure X. Then the answer will not by the Urban Development Department. Therefore, it is not the extract of a particular MOSA map prepared by GSI by the UD department. Then it says that is so. Then you will agree with me that this document has been approved by DSDA only and none else. The answer is the map is approved by not DSDA but also approved by the Urban Development Department, Government of West Bengal, and prepared under the guideline of GSI. Then from which part of the said document it would be indicated that it was prepared under the guidelines of GSI? There is nothing to indicate that the same was prepared under the guidelines of GSI. Then shown annexure X, whose handwriting in it at the top, Mr. Nuni Chondo Amin. Then who has shown this box said to be the location of the alleged disputed structure? Mr. Nuni Chondo. Do you have any idea about the mode of measurement followed by the said surveyor for locating the alleged structure? I do not know. Were you present at the time of taking measurement by the said expert, Mr. Deval Roy? Yes. Do you have any knowledge about the mode of measurement followed by Sri Deval Roy? No. Do you have any idea about the instrument used at the time of taking such measurement on 5/9/2010? I do not know the process. Will you agree with me that the measurement arrived at based on the latest technical concept by Sri Roy is much more accurate than the measurement alleged to have been shown in the annexure X? I cannot say. Come to the report of Mr. Roy. Were you present at the time of taking measurement as to the latitude and longitude as to the points shown A to F on 5/9/2010 in the presence of the arbitrator? Yes. Do you remember that the arbitrator put questions to both parties as to whether we were in agreement with the points chosen by Mr. Roy? Yes. Do you agree that the latitude and longitude at all such points A to F have been taken in the presence of the arbitrator on 5/9/2010? Yes. Did you raise any objection at the time of taking such measurement as to the latitude and longitude at site? No. Have you gone through in between lines of the said report given in 2 pages? Yes. Do you find that the name of the instrument used by Mr. Roy is contained therein? Yes. Do you have any idea about the functioning of the instrument? No. How do you dispute the report given by Mr. Debol Roy without having any knowledge about the technical and or mode of taking measurement or the functioning of the instrument used by Sri Debol Roy? As far as I know, GSI has taken the measurement and based on that, pillars were fixed in respect of 200 meters and 500 meters. From the said report, it is indicated the location of the alleged disputed structure is within CRZ 500 meter zone. When you placed the said GSI drawing for the first time before the arbitrator, then 5/10/2010, what prevented you from disclosing the same before the engagement of Sri Debol Roy? We have not asked earlier to produce any document to substantiate the respondent's contention with regard to the location of the disputed structure. Then what are the suggestions?
So, my lord, you will see from the cross-examination that, my lord, they have never disputed the report of the, or they could not have also disputed the report of the expert.
Yes.
And the map which the learned quote below sought to rely on emphatically was not the actual map also. It was Xerox copy. Not even a certified copy. And not brought on evidence. That is most important. Not brought on evidence. So, my lord, the section 34 code, without ensuring that these findings are based on facts which have been shown and proven or disproven, whatever it may be, before the arbitral tribunal chose to rely on unauthenticated Xerox copies unverified maps of the GSI, LS GSI, which they also say the GSI was not called upon as a witness in support of its map.
Yes.
Similar, what the under 34 code does is substitute its own opinion instead of the expert opinion, which in a section 37 application, section 34 application, which my humble submission is, we cannot do so. Similar, Arbitration Act है Arbitration Act है
দুটো দিয়ে দেবো হ্যাঁ তোমারটা আছে তোমার কাছে section 26
So Lordship will kindly come to page paragraph, sorry, section 26. Lordship,
I can have দুটো হয় জজ সাহেব and may I please section 26
Yes.
expert appointment by arbitral tribunal. Subsection 1, unless otherwise agreed by the parties, the arbitral tribunal may appoint one or more experts to report to it on specific issues to be determined by the arbitral tribunal and require a party to give the expert any relevant information or to produce or to provide access to any relevant document, goods or other properties for his inspection. Then subsection 2, unless otherwise agreed by the parties, if a party so requests or if the arbitral tribunal considers it necessary, the expert shall, after delivery of his written or oral report, participate in an oral hearing where the parties have the opportunity to put questions to him and to present expert witness in order to testify on the points at issue.
repeatedly, expert was appointed at the suggestion of the parties. Expert appointed was the nominee or at the suggestion of the DSGA. Because we have stated that we do not have the expertise, or we don't know someone else would replace this expert. Number, it was
Yes.
it was well within the rights of DSGA that having regard to section 26(2), they could have called him for examination. They chose not to. In such a situation, would the section 34 go into the correctness or the otherwise of the opinion of the expert? And that too in such a manner which not only is perfunctory, but is also purpose.
Yes.
Now, your lordship will see, I think after this thing, your lordship will see that the only ground on which the section 34 court came to a finding that the award was bad and opposed to public policy is that the report of the arbitrator, of the expert, was not in sync with the details which were required to incorporated in the report, which is also factually incorrect. Number two, that this area was the subject matter of a CRZ area, B7, so naturally the entire thing was bad in law. Number the respondents had relied on a notification of the Union of India issued by the Ministry of Environment in Malad. যেটা গ্যাজেটটা আছে সেটা দেখো না ভাই কালকে দিয়েছি উইথ এ প্লেস রিলায়েন্স জজের সে বলছিলেন দাও ভাই
হ্যাঁ ওরা already- হ্যাঁ হ্যাঁ ফাইল করা আছে ওখানে। হ্যাঁ হ্যাঁ
Yes.
This was before the arbitrator, this one.
No, this was for the first time they brought it to the notice of this court.
Section 34 court.
No,
Oh.
section 37 court.
Oh. Hmm. Yes.
But these are facts which cannot be disputed. I'm not disputing also. That if an area falls within the CRZ, I'm the last person to wade my body in the water and get taken away from by the ocean. I'm the last person. But I will see what is there and how things can be done. The will see particular clauses which are very vital.
Your Lordship, can you take the English version, my lord?
Yes.
First the Hindi version. English version, my lord, kindly see clause 6. My lord, clause 6, my lord. This is page 6, my lord.
This is under section 3.2 of the Environment Protection Act.
Lordship, lordship, lordship.
Clause
And
6.
I was just referring to, my lord, page 6, my lord. Pagination is on the left side, my lord, top left side. Page 6, and my lord, on the right hand side, clause 6. My lord.
Yes.
The heading, your lordship will find annexure 1, then under coastal area classification and development regulations. Classification of coastal regulation zone. 6.1. For regulation development activities, the coastal stretches within 500 meters of high tide line of the landward side are classified into 4 categories. Well, I skip over A, my lord. They say this is CRZ2. So the next entry, my lord, will find category 2 within bracket, my lord, CRZ2. Just after the first one. One of the areas that have already been developed up to or close to the shoreline. For this purpose, developed area is referred to as that area within the municipal limits or in other legally designated urban areas which is already substantially built up and which has been provided with drainage and approach roads and other infrastructural facilities such as water supply and sewerage mains. Well, this is CRZ2. Now kindly turn over then to the next page. Then just from the top plot after 6.2. Lordship gets that, 6.2. The development or construction activities in different categories of CRZ areas shall be regulated by the concerned authorities at the state, union territory level in accordance with the following norms. Then we will kindly skip CRZ 1, CRZ 2. The next one. Buildings shall be permitted neither on the seaward side of the existing road or roads proposed in the approved coastal zone management plan of the area, nor on seaward side of existing authorized structures. Buildings permitted on the landward side of the existing and proposed roads, existing authorized structure shall be subject to the existing local town and country planning regulations, including the existing norms of FSI, FAR. Reconstruction of authorized buildings to be permitted subject to the existing FSI, FAR norms and without change in the existing use. The design and construction of the buildings shall be consistent with the surrounding landscape and local architectural style.
Lord, perusal of these clauses would therefore show two things, Lord, in my humble submission. That there is no total embargo to construction. It is a regulatory act because it says it should regulate, not a total embargo. Within a particular area you cannot, but you can regulate. And your Lordship will also see the date in which the notification was made. That was in the year 1991.
This is one of February 20, 1991.
February 20, 1991. So therefore, to say that the government of West Bengal was unaware or the Diga Shankopur authority was unaware of the existence of this gazette notification, and despite knowing the existence of this notification, they chose to invite tenders for construction of a 690 stall in B7 area, which according to them, I'm assuming, falls within an area of 500 meters.
Yes.
Now the question before your Lordship will be to choose whether the report and the findings of a expert appointed by a tribunal with the consent of both the parties and the reports not being challenged by the respondents would have precedence than to the Xerox copies of unverified and maps which are not never the subject matter of any evidence. You the arbitration. That is one thing. Now, assuming my lord also for arguments here, lordship is not with me. That yes, this is after all a public issue. We cannot permit you to hold. I have to make any concession. Now the question would, am I making the concession? No. I was invited to make a concession, and your lordship will see the memorandum of understanding as to how the concession would have to be made. 24 months, 690 stalls had to be made with the P7 area in an area of 7.5 acres. Up to 40% of the total cost involved would have to be borne by the contractor, and thereafter file its claim bills. So up to 40% of the total area, and the amount was 5 crores.
26,000 lakh 95 crore 26 lakh
5
90,000
crores 26
lakh
lakhs.
90,708.
So, but out of that, I would have to pay up nearly 2 crores and odd. At the first instance, we were claiming even a single paisa from the DST. Thankfully, my lord, thankfully, our said, now, my lord, the report of the order, your lordship will see passed by the section 34 application code, does not deal with the award which was which has been granted by the arbitral tribunal, and the various rounds of claim which has been allowed by the arbitral tribunal. As I stated on the very opening day, that there was, after the suspension of work and thereafter the cancellation of the work order, a fresh tender was invited by the respondents, which was again not proceeded with, having found out that we had also further participated. We had made a claim for payment of the monies which we had already expended. We had never filed a writ petition for this honorable court challenging the cancellation.
24th March 2005 তারপরে কনস্ট্রাকশন চালিয়ে গেছে জিজ্ঞেস করবে 24th March 2005 when the suspension notice was issued, don't you think the appellant should have immediately stopped work?
Yes, we stopped work.
You stopped work?
Yes.
After that you did not do any work?
Let us say that this is the entire area, and the portion has to be.
It was discovered that despite issuance of
It's 21st April, there's another letter from DSDA saying that you are continuing with the work.
Yes. The lordship is aware that a huge area which has been suddenly, which has been going on, work was going on, sand, cement, stones, steel, iron have been accumulated and they have been picked up. Suddenly, in the midst of the work, if anything has to be stopped, all of a sudden it cannot be stopped. It has to be the entire area. So long as it is within my control, I will have to safeguard my own materials. So, my lord, I have made certain claims which was rejected by the learned arbitrator. I'm not even claiming that also. What we had made 13 claims. Some, as I followed from your lordship, absolutely correctly. I made an application, but I know that those were not granted and could not have been granted. So your lordship need not go into that aspect of the matter that we were or we did not. The issue is very simple. That both the parties jointly agreed
Roughly how long will take, Mr. Kundu?
not. I am at the fag end of this argument, not.
Yes, so can we continue at 2 o'clock?
No, not today, 2 o'clock. I'm going to fix matter in this happy place. And the problem, because of this matter, I kept the other matter.
No, so then we'll have to give another date to you. You will not finish in 4 minutes, will you?
No,
That's what we have.
because I am also fortified by your lordship's very recent order. I think.
Judgment.
Judgment, my lord.
Your lordship's judgment.
So you will take a little time which won't conclude before recess.
No, I will not do. My research.
Thursday 2 p.m.
26th.
আচ্ছা তুমি free আছো?
Uh,
It be Thursday at 2 p.m. my lord. This Thursday
26th. 26th.
26th.
We are very hard pressed for time.
The senior lordship, Mr. Pajawas, matter only your lordship is not.
26th কটার সময়?
I'll take half an hour maximum.
12:30, 12:30, 12:30. Mr. Lekho,
আমরা কি
অভিজিৎ,
পরের দিন
এটা নাও।
তাই তো বলছি কারণ
May proceed.
2 p.m. আমার ফিক্সড আছে একটা সেদিন আমার
Mr. Kundu, that is senior counsel representing the appellant, resumes his argument but does not conclude. Paragraph. List this matter once again on August 26, 2025, marked 12:30 p.m.
Your Lordship, I crave to leave mention the instant matter. I had mentioned the matter in morning for upgradation. The interim relief, we are enjoying an injunction, but it is expiring in the month of August. Your Lordship had asked me to get the service report.
Yes.
Can I please file it,
You
Your
served
Lordship?
notice of this mentioning?
Yes, I had served it yesterday, but the report was not ready. I have it now.
Very well. To be mentioned? To be mentioned to appellate side or original side?
Original side.
Tomorrow?
Obliged, Your Lordship.
me in the second appeal, which is, we have said that we are the main appellant.
No, he's
And
not.
other appeals are mainly strategic appeals. Then the Lordship had read the impugn order on the previous day, and Lordship had.
I'm the Section 9 applicant.
I'm the Section 9 applicant.
Who is Mayur? Who is Mayur Punk?
Mayur Pang is Mr. Bachawat. But I'm the Section 9 applicant.
Earlier, I am the only one who had made my submissions earlier.
Lordship, I'm the real appellant.
My hearing.
We all had made submissions in the first round.
Whose appeal was heard first, Mr.
My lord, everybody was heard.
Yes,
now
whose appeal was heard first? Mine. Now, my lord.
My lord, we are the main agreed person. Other persons, we are.
Very well. Feel agreed for some more time. Take your seat. Let us hear.
But I'll just keep it in a very short compass.
Hear everybody, Mr. Sharma.
Lord, I'll keep it within a very short compass. But for the time being, don't touch the papers. Let me just give your lordship the background. But this relates to a property which your lordships probably see on the way to the airport. Lord, as one is on the flyover and turns left, Lord, there is a Marriott and there is a service apartment next to it called Vivara. So this relates to that property. Now, this property was not, if your lordship see, there are 4 names. I won't tell your lordship who's the respondent here for the time being, because Lord, there was a company called Fabworth. Now, Fabworth was then controlled by a company called MRMGF that acquired rights to the property with the right to build on it from the KMC. It ultimately disposed of its shareholdings to 4 companies. 3 companies, sorry. One company called Raddin, and 2 other companies called Money Square and Satwa. So there were 3 groups. Now, the dispute arises out of a shareholders agreement between them. Now, this agreement was entered into in 2011. So, these companies were to acquire control of the shares of Fabworth, which owns this property, and then finish the construction and run whatever has to be done.
This property meaning the service apartment?
Service apartment and the hotel.
And
both,
the hotel.
Entire. So, these shares went in. There was a shareholders agreement. Like I said, really speaking, 2 groups which we are really concerned with now. Originally, Money Group, Satwa Group, and there was a Raddin Group. Now, over the course of time, Raddin Group went out completely. And other shareholders came into the agreement of 2000, came into the control of these companies. Because a lot of money was required to build, there were claims by the banks and other such things. Bank issued notice under 13(2), and the Satwa Group, who had one director in this company, their director resigned and went away and took no interest. The remaining shareholders thereafter pulled in money, got in other promoters, took care of the litigation against the bank and all of that. And ultimately, when things were all right, suddenly they wake up again, the Satwa Group, and they say, look, you can't do this, that, and the other. And they filed a Section 9 application challenging a EGM to be held. So it is in that Section 9 that an order, incredible order, which no one could understand, because that is their grievance, that is our grievance. So the order says status quo of 2011, really speaking. By then, the status quo is completely gone because Raddin has stepped out of the picture. Any number of other shareholders have come in. Agreement has been terminated, original has been torn up and thrown away. That is the affidavit given by others. So that agreement was not in existence. Now the Section 9 is filed. I am not a party to that arbitration agreement. I have come in subsequently. I have come in subsequently. I am not a party to the agreement. I am not bound by it. The other relevant factor is, which is important.
You are also not a party to the Section 9.
I am. There is a specific pleading in the Section 9 that no relief is sought against me. Para 3, I'll show that to your lordship. Specifically says no relief is sought against me. Now, if the status quo of 2011 comes back, I am certainly affected.
How have you come into the
picture? He's made me a party. I have purchased shares. I have acquired.
In shares in?
Lord, there's a chart there. I'll show your lordship. Over time,
Various companies.
No, no.
Shares,
Not the appellant before your lordship is one company, Mayur Punk Traders.
yes. You have
Shares of Fabworth.
Fabworth.
Fabworth is not, let's call it the target company at that point of time, which is the owner. The dispute arises out of not this company now.
Mayur Punk and Mayur Pankhi are different parties. There's one Mayur Punk Traders Private Limited, one Mayur Pankhi.
Oh, I see. No, it's Mayur Punk only. It's only Mayur.
One. There's a typographical error then in the order.
Yes, in the order, yes.
Pradyumna Kumar Mishra, who's Pradyumna Kumar?
He represents the Satwa group. He is no one. He is actually no one.
Mishra or Sharma?
Mishra.
কি এখানে একবার প্রদ্যুম্ন শর্মা লিখছে
Pradyumna Kumar Mishra is the appellant number 1 in item number 2, the second appeal.
So there's one Pradyumna Kumar Mishra and there's also one Pradyumna Kumar Sharma who's a party.
No, only Mishra.
They must have mistaken Mr. Dhiren Sharma with. He of course has more asset. He probably has more asset.
Money Square is also a shareholder in Fabworth.
Yes.
So is Pradyumna Kumar Mishra. No, that's
through the appellant number 2, which is the Satwa group.
Satwa.
Everybody is a shareholder in Fabworth.
How it can be true is not understood, but
no, Pradyumna Kumar Mishra is a separate appellant in a matter.
Yeah, so he's the petitioner.
Pradyumna Mishra is that Pradyumna Mishra is yes, Pradyumna Mishra is part of the Satwa. I will explain.
He is not a party to the arbitration.
And the money.
He is not a party to the arbitration.
What is your grievance now?
Yes, I'm just coming to that. I just gave your lordship the background of the dispute. So, my lord, what has happened is, not old shareholders have gone out. That agreement was torn. There's a new group of shareholders all over the place. Now, he filed an application, or rather, he filed an application under Section 9, asking for reliefs against a EGM to be held. Now, there is a specific pleading that he is not seeking reliefs against me, but he's made me a party.
He is Pradyumna. No.
Yes, Pradyumna along with Satwa.
Along with Satwa.
But in my memo of appeal, not R1 and R2, respondent number 1 and 2, filed that application. Now, if your lordship has the paper book, or is your lordship looking at the looking at the paper book?
Memo.
The page to follow. No point saying it's there.
There is a separate compilation here.
But the memo of appeal is at page 60, 620.
They have only given that with all the relevant documents, which I think they only gave it, and we are all relying upon that, my lord.
Your lordship can look at from the compilation also.
There are 5 volumes, compilation, 5 volumes. 5 volumes of the compilation and
which is why I said
Aditya Kanuri has made it. Very good. Very good compilation. As you always do.
So the font choto hai.
As he always does. Very
One
good.
second.
Font choto hai ke poste
I will look at this memo. এটা দাও নাকি এইটা মেমোটা এরকম ভাবে নাকি দাও Who is the respondent number 2 in your memo? Is this your memo? Mayur Punk,
yes.
Who is the respondent number 2?
Should be Satwa. Oh, missing. No, there is no missing page either. But in my copy, but I have been favored. With something your lordship has not noticed. But I think it's to do with A4 and non-A4 maybe, I don't know. It's got cut out. Possibly.
Oh, well, we have
in our appeal, everybody is there.
Yes.
You have got number 2, we haven't.
But it's probably to do with the size. I don't know.
This is actually our appeal. This is our appeal.
No, unka appeal bhi hai.
Then it would have been on every page. Anyway, rectify it. Do whatever is necessary. Yes.
Now, my lord, your lordship need not be troubled with the papers for 5 minutes. I'll just give your lordship the background. It will become much easier. So, like I said, Lord, I am not a party to the shareholders agreement. That shareholders agreement had a arbitration agreement under which that section 9 is filed. He specifically says so in the petition, and he says no relief is being claimed against me, but he adds me as a party. Now, 2-3 things are important at this stage. This shareholders agreement is not incorporated into the articles of Fabworth. So, there is a line of judgments which your lordship is aware of, which says clearly it is not binding on the company unless it is incorporated into the articles. So, I'll leave that aside. Now, But this is the situation which happens. Now, I'll just tell your lordship very briefly what my grievances are. Number one, not a party. Number two, my lord, he says no relief is claimed against me. Number three, my lord, I'll show your lordship from my application. According to the original parties, that agreement was torn up and thrown away. There is no agreement. We asked them for inspection. They have refused to give us inspection. So the original does not exist at all. It has not seen the light of day. Lord, this is 3. 4, Lord, I am just giving your lordship all my points so I can take your lordship there. The order in question is completely unreasoned and no one can understand it because that was his case. He asked for modification of that order, having got the order. He construed it in one way. In appeal, he is construing it another way. And the specific submission made was it's unintelligible. Lord, I have that written down in my notes. So, Lord, this is the third part. Fourth, Lord, it orders a status quo without ascertaining the status, which Lord, the Supreme Court says cannot be done. It is not a practice which one should do. First, ascertain the status before you pass an order of status quo. 5, Lord, it returns the status quo to 2011, which can't be done, Milord. It's a mandatory injunction at the ad interim stage. Now, the test, as far as I know, Milord, from 1956 Calcutta, Milord, non-known pictures and all the judgments your lordships are familiar with. But at the interlocutory stage, a court has the power to grant mandatory injunction, but only in extreme cases, and that too only to maintain the status as on the date of the filing. It cannot restore it to 10 years ago. So, Milord, that will be the next point I'll take. Now, in addition, Milord, there's questions of delays. There's a suit filed by us in relation to this. And, Milord, he did not file any application for, not Section 11 application for appointment of an arbitrator for 2.5 years. 2.5 years, 3 years, now he has filed it. After, Milord, the matter is to come up for hearing. And, Milord, really speaking, the application has also become infructuous because what he challenged, Milord, the order did not have the effect of preventing it. Milord, new people have come in who have paid money by which, Milord, the banks were paid off. That was the object of the EGM, Milord, sums in excess of 100 crores. So that those payments have been made, it's all done and over. Milord, this is the long and short of the matter. Now, Milord, of course, Milord, and other than that, statutory bars there, Milord, bristling with legal points, Milord, statutory bar, affairs of a company, bar under the Companies Act, Section 430 of the Companies Act, Milord, EGM, appointment of directors, removal of directors, all that, Milord, are exclusively, Milord, it's now settled, Milord, these are all to be decided, Milord, by the NCLT because of the exclusion under Section 430. So, Milord, bristling with points, but, Milord, may I keep it very short and simple and just show your lordship 2 things before I take your lordship to the order. Lord, number 1, first, if your lordship would take. Lord,
who's Satwa?
But Satwa is Mr. Abhijit Mitra, perhaps. Lord, there are many parties representing them. There are 5, 6 parties there. Lord, or 4 or 5 parties, not all on the same side. And here also, your lord.
I myself, my 2 affiliates.
Very well. So 3.
It is between 3 of us.
Yes.
We don't know who's appearing for whom. We are all together.
What are the names? Satwa?
Satwa,
Lakshmi Narayan
and
Prajapati.
And Prajapati.
Just give me
Commerce.
3 of them. 6 and 7.
Yep.
Lakshmi Narayan.
Lakshmi Narayan Vyapar Private
Number
Limited.
6, I think, is Mr.
Okay. Satwa, Lakshmi Narayan and Prajapati.
Prajapati. Similarly, they have also affiliated.
Not Prashant.
No, Prashant.
Pradyumna, sorry.
Pradyumna is there. He's part of Satwa.
Right, but Pradyumna is a party you nominee.
No, Satwa.
Oh, no, he's our officer.
Officer. Officer of Satwa.
The director of petitioner number 2.
No, don't get into it.
We সবাই 3 জনে মিলে কে কার হয়ে জানে না
That would be a
করছে
Now, Milord, if I may just start off my submissions. Milord, if your lordship first takes the paper book, page 54, volume 1, or compilation. Milord, please take the compilation. It may be easier, as my learned friends say.
Compilation আছে আলাদা কিছু এটাই কম্পাইল হ্যাঁ ইন্ডেক্স তো কম Page 54.
Yes. Lord, I'm only showing it for the limited purpose of showing your lordship who the parties are. But parties there, first party is Money Square, second is Raddin, third is Satwa, fourth is Fabworth. 4 parties. Your Lordship can make a noting. Since then, Raddin, admitted on the petition, has gone away. Raddin is no longer there at all. That's the admitted position.
Is that Raddin Hotel still there on Loudon Street?
No, that was not broken down and a fancy building has come up there, my lord.
Achha.
Fancy building, my lord. Mr. Sharma, I believe, has a couple of flats there.
I see. Money. The key developer.
So, my lord, these are the 4 parties. Now, my lord, please take the cost title of the Section 9 application, which is at page 17 of the same volume.
Fabworth, Satwa, Raddin, and Money Square.
Now, to make it easier, Fabworth is the target company. Money Square, Raddin, and Satwa were the not shareholders. Ratio was 40-40-20. Not relevant for present purposes.
Yes.
Now, my lord, if your lordship sees the petition filed before the trial court, that's page 17 of this compilation. 17, same volume. Now, please have a look at the cause title. Number 1, petitioner number 1, Pradumna Kumar Mishra, not a party to the arbitration agreement. Satwa is a party. Then, my lord, see the respondents. Baglas, not a party. Respondent number 2, Money Square, is a party. Respondent number 3, Mayurpank, is not a party. Respondent number 4, Right Click, not a party. Amit Chaudhary, not a party. Lakshmi Narayan Vyapar, not a party. Prajapati Counsel, not a party. So, my lord, out of the first 7, your lordship will find only 1 was a party, which is the respondent number 2. Then Fabworth.
Prajapati is also not a party.
No one. None of them.
Yes.
And Raddin, which was a party, is not made a party. So this is the frame. Now, since your lordship is on it, so I don't have to take your lordship back to it, please turn the page to page 21.
The shareholders agreement was of which year?
2011.
11. Raddin went away when?
Raddin went away. Just give me a moment. 2014. 15.
This
2015.
petition is of 23.
Time.
You appear, Mr. Banerjee is also appearing. I see.
Not there are several parties opposing and proposing and not supporting. So
One side. Please, Mr. Mashawat, don't give the impression that they will supporting.
Of course,
you know very well.
in the world, Lord, there is only good and there is evil. There's good and there's evil. So, Lord, it is good versus evil.
Don't mix up the good with the evil. Clear cut evil, clear cut good.
So, Lord, 2 sides only is right. Now, Lord, if your lordship sees how evil it gets, page 21, which is para 3 of his petition. Now, please remember, Mayurpank was respondent number 3 in that application I've showed your lordship. Now, this is that same application. Please see, Lord, page 21, para 3. Oh, my lord, I'll read the whole of para 3. Respondent numbers 1 and 3 to 7 are the other shareholder of the respondent number 8. It is submitted. Respondent number 6 and 7 being an affiliate of petitioner number 2 within the meaning of SHA. Similarly, respondent numbers 1 and 3 to 5 being an affiliate of respondent number 2 within the meaning of the SHA are deemed to be parties thereto. Not parties, deemed. He is deeming it. and have been impleaded as respondents in the present petition as their presence is necessary for proper and effective adjudication of disputes between the parties. Now, my lord, please mark it. Though no relief has been claimed against them. So very clear, he is not asking for reliefs. Now, two other things. Lord, this is not a suit. Can you add a party because their presence is necessary for proper and effective adjudication? CPC, not for addition of parties, says, well, someone may be a necessary and a proper party, or someone's presence is necessary. In a section 9, you cannot have him this way at all. And I'll show your lordship the latest Supreme Court judgment on this.
Yes.
So, my lord, one, I'm not a party to the shareholders agreement. Two, he says no relief is claimed against me. Now, my lord, I'll just keep it within this short compass for the timing and take your lordship straight to the very well. Before that, I'll show one more letter, my lord, which your lordship would take can 3 once. Can 3. Letter. No, if your lordships have got
your appeal number is 28.
Yes. Now, my lord, when they initiated these proceedings, my lord, we were a little surprised and taken aback. We're not parties to all this. So, my lord, we wrote a letter, my lord, which is at page 8. Please come to this letter at page 8. So now, my lord, this is being written to a promoter and who was in control of the Raddin group, which has gone out. So, my lord, we write to him saying, my lord, page 8, 26th of July 23, Namaskar, Calcutta can't forget your efforts in being married as a promoter of Fabworth. We are having so many shares. These shares were purchased by us from the company. JW Marriott became a NPA with the Punjab National Bank, and PNB has agreed to restructure the account. Over the past 2 days, court proceedings are continued by Satwa Group against the company and us. From the court proceedings, we find that a shareholders agreement was executed between promoters of Fabworth in 2011, and it is said that the shareholders agreement is binding on us since we purchased the shares of Fabworth in 2015. We met through a common friend. Can you enlighten us in this matter as we are confused? We are sending you a copy of the court petition to you. Now, my lord, please see the response of Bipin Bohra, which is Raddin Group, which went out. I am in receipt of your letter. I am happy. Not page 9. I'm sorry, that will be page 9. I'm happy that PNB has agreed to restructure the account of Fabworth as discussed when we last met. The shareholders agreement dated 31st March was signed between me representing Raddin, Sanjay Babu representing Money, and Bijayji representing Satwa when we three were together. And we agreed to share costs of the project 40-40-20. When I was quitting, Sanjay Babu wanted Bijayji to share the future costs as Money 2/3, Satwa 1/3, to which arrangement Bijayji didn't agree. Since the shareholder agreement was terminated between us, when I was quitting the project, I, Sanjay ji and Vijay ji, sitting together, tore and destroyed all the 3 original copies of the agreement dated 31st March 2011. So, my lord, agreement does not exist. He is not starting an arbitration under these letters. No, asking them for copies. Now, my lord, turn the page. So, my lord, on this basis, page 10, I ask him for inspection. My client requires to take inspection of the original agreement on the basis of which present proceedings have been initiated. You are therefore requested to provide us inspection of the original agreement. To my client within office hours, it's also important to state that this matter is incomplete. No, Lord, that's corrected in the next page saying that that line is not incomplete. So, Lord, we asked them for inspection. No reply. No reply. Lord, therefore, Lord, two things here. My learned friend is claiming whatever he is claiming on the basis of agreement. Now, one can say it could have been an oral agreement and filed a suit. This is a case where Lord, the arbitration is being initiated on the basis of subsisting agreement, which according to one of the original parties was torn up and thrown away. It's not there. It was put to an end. And that's borne out by the fact Raddin has gone out. Other people have come in.
If all the parties are agreed, why don't we just set it aside and send it back with the direction to direction to question.
हमारे वाले तो remedy करते तो
Proceeding under the Arbitration Act.
हमारे वाले का पेज
फिर दिए थे
resignation चलो खोज के निकाले. I thought you all know all the pages.
No, what we were wondering, if all concerned are unhappy and with the order, why don't we send it back with a direction to first decide whether an arbitration petition is maintainable?
Done. Lord, I have no problems.
What about the others?
I am the only agreed party. Well, I shall be asking for certain. I am the only agreed.
You shall be asking for further orders here.
I shall be asking for orders here because it is all there.
That application for Section 9 has been disposed of.
No, my lord, it is still pending. I had immediately after the order was passed, I made an application for clarification within 2 days. That paragraph 13 says I am of the prima facie view that this injunction should be passed because this on the
So let me take your lordship to the order. He can make
place.
that submission.
Yet to take place.
Let Mr. Bashwat.
Let me just place that order, then he can react.
Conclude, yes.
He can react. He can. One last thing before I go to the impugned order. Lord, please take page 76 of the same compilation. Your lordships are on the compilation, Lord. I'm giving pages only from there. Now, your lordship can make a note here. This letter is by Mr. Vijay Kumar Agarwal, who was the nominee director of Lord Satwa Group in February. Now, these gentlemen, Lord, what had happened was, Lord, after Raddin went out and various other shareholders came in, Lord, huge debts had not been incurred by February, in relation to which Punjab National Bank, Lord, had issued a 13-2 notice. Now, proceedings took place and all of that, but when the 13-2 notice came, their nominee and the only nominee on the board resigned and went away. Now, please see that letter of his, which is page 76. 5th of October 2021. I, Vijay Kumar Agarwal, hereby tender my resignation from the office of director by February and with immediate effect. I request that my resignation be duly taken on record and necessary filings be made by the Register of Companies and other appropriate authorities. I trust you received my letter dated 4th October seeking clarification in respect of the loan granted by Punjab National Bank and subsequent notice from the bank in connection with the defaults in the facility and consequent action proposed to be taken. Considering my continuing shareholding in the company, I would request that these documents be provided at the earliest. You are requested to provide an acknowledgement of receipt of my resignation, etc. So, my lord, seeing that the bank was going after, he suited, my lord, he just resigned and left and went away. Now, my lord, after I have obtained filed proceedings, orders passed against the bank, settlement with the bank, restructuring plan of not another person coming in and putting in the money to pay off the bank. After this happens, not suddenly a loss-making venture, not to him now it seems that, well, it is now a ripe fruit, a riper fruit for the picking. Now let me creep back in.
What is the percentage of your shareholding in Fabworth?
Lord, mine is, Lord, I'll give your lordship the chart, about 6%. 7% or so. I'll just give your lordship that chart is also annexed. 245 now, which shareholding chart here, down page 27. So, 27 of the compilation. Axiom, this is inner page, para 15, para 15. Lord, that will be page 27 of your lordship's compilation. This is their case. So they have given the present shareholding. From 40, 40, 20, this is what it becomes at the time of filing, according to them. Baglas, 10, Money Square, 57.6, Mayurpunk, 6.8, Right Click, 1.2, etc. And Satwa, not which is them, please turn the page. Satwa Developers, 1.55. And Lakshmi Narayan and Prajapati, whose shareholding is now not including, is not a party, not a petitioner, not a petitioner. So, my lord, he on his own is 1.5%. And petitioner number 1 is 0%. Not a party to the agreement. So, my lord, what had become then a rotten fruit, once revived, not arrangements made to pay off the bank and all that, all this resignation and all that he forgets. And he says, look, don't pay off the bank without my say-so. And that's the EGM he tried to not stop. A EGM was not called for the purpose of approving all this and to pay off the bank, with whom a settlement had been entered into.
EGM of Fabworth.
Yes. Yes. So this is what the game was.
That is the section 9.
Yes. Yes. Section 9 filed saying don't hold the EGM by which you are agreeing to pay off the banks. Where he had gone to sleep, 21 he had resigned and gone. And he had notice of this EGM at least a month prior to him filing it. He filed it not 2 days before the EGM, as far as I remember. 2 days. Yes. So 2 days before the holding of the EGM, he files it. Not the EGM was to be held on 30th of, a notice was dated 30th of June, and the EGM was scheduled for 29th July or something. That was the 27th. So, EGM notice is at was on 30th of June, which is at page 84. If your lordship wants to make a marking, and the meeting was scheduled for 27th July, and he came to court on 24th. He filed the proceeding on 24th of July, and it was moved on 25th of July. So, he waited till the last moment.
Let us see the order.
Yes. Now, let's go to the impugned order, which is at page in one of that compilation. But I'll take your lordship into submissions. But a little later, let me take your lordships straight away to the findings, if I may. Straight, just to show your lordship what's going wrong. But up to para 10 is submissions, or even 11 is submission. It is submitted. But para 11 is also submissions.
12 is also recording.
12 is also. Now, 13. 13 is from the foregoing discussion. It is a sum up. And before that, may I just indicate all the objections possible are taken, no arbitration agreement, Companies Act, bar under, etc. All that is done. None of this is being decided, and please see what's being held. From the foregoing discussion, it is sum up that the instant application has been filed in lieu of urgency, that the matter in as much as the respondent number 8 company, at the behest of the respondent number 2 and respondent numbers 1 to 5, has vide its letter of 12th July 23, refused to adhere to the positive obligation casted under clause 6A of the SHA to appoint the nominee director of the petitioner number 2 and the respondent number 6 and 7. Contemporaneously, the respondent numbers 1 to 5 and respondent number 8 company are now proceeding to hold an EOGM in pursuance of the notice of 30th June 2023 and decide on reserved and or affirmative vote matters falling under clause 6B, 6B4, 8 and 6C2 of the SHA respectively, which shall result in the valuable right of the petitioner number 2 being irreparable damage or prejudice. So, my lord, here he is only summing up the submission. This is not a finding. Now, my lord, para 14. Considering all, it is found that this court at this stage, when this court is in the locus to determine an application under Section 9 of the Arbitration Conciliation Act, it is only to be looked into whether the periphery of the provision of Section 9 and not more than it. Now, my lord, this is some foreign language, my lord, I don't know, my lord, some use of big words, not completely indecipherable. In this case, opposite parties have come and made their oral submissions, but they are not in a position to file affidavit. How do I on the first day? I'm served at 8 in the 8 at night. Next morning is the matter. And he says, I'm not in a position to file affidavit to the instant application under Section 9. Therefore, this is the only reason. Therefore, considering the same, it is opined that a status quo of the SHA in question should be maintained till filing of affidavits by other side to the instant Section 9 application. That be so, the court directed to maintain the status quo of SHA based on the terms as delineated therein till the next returnable date as fixed. Now, my lord, terms delineated therein 40, 40, 20. How is that possible? Terms of the SHA.
Now you have all filed affidavits.
My lord?
Have you filed affidavits with the Section 9?
No, it was challenged. Not straight away. We've challenged the maintainability over there, and that's how it's been lying for so many years. He did not even seek to refer it to arbitration for 2.5 years.
In the appeal, is there any interim order? No.
Yes, restraining them from making publications, because what they did after this, relying on this, please see the newspaper publication made. Lord, it's strange. My learned friend claimed that the order is in his favor, and today your lordship finds he is the appellant. Clarification application.
When did they apply for? When did they institute the Section 11?
But Section 11, 2.5 years later. 2.5 years later, I'll give you a lot of break. In 25. Now, sometime just. Now, there's a line of old judgments which says you must be ready to willing to go to arbitration and display that intention. But Justice Pal had almost indicated it's like a period of limitation of 3 months.
That's what we did. Section 9 order. Right. When was the Section 21 notice issued?
But I'll just pull out those dates. Pull out those dates, please.
26, same way.
I'll just see it from the pleading. Yeah.
days. Returns.
21st October 2020. 20th October 23.
20th October.
No, that was for a different agreement.
It was a corrigendum.
Yes. Yes.
30th?
They referred to some other agreement. So we said, please give me a copy of that agreement.
No, in respect of this agreement,
in respect of this agreement, my learned friend will show when he'll show it.
Anyway, I'll make myself.
why we are asking, you're aware of section 9, subsection 2 of the Arbitration Act.
Yes, Munot.
When an interim order is passed by a court, then steps have to be taken. The arbitral proceedings shall be commenced within period of 90 days.
Correct. That's what I say. It's
Commencement is section 21. Notice.
He issued it on the 90th day, but in respect of a different agreement. But I'll be frank here, it may have been a typographical error, but the fact is he referred to a different agreement. So we wrote to him asking for a copy. Please send me a copy of this agreement also. You're not showing me the original of that one and you're referring to one more. Please send me a copy. So this is the fact. Not now, whether it's error or malafide, my learned friend will laugh it off. No. Lord, my learned friend can now try and laugh it off, but these are important matters. He waited 2.5 years to even not start his section 11 thereafter. So, Lord, these are all matters. These are not laughing matters. Lord, you can't go to court, Lord, and obtain a snatch interim order, sit on it, construe it in a particular way. He says he has got an order restraining the EGM. Your Lordship has seen the order. There's nothing about the EGM over there. It says status quo of the terms of that SHA. Please see, Lord, what he does then. Immediately thereafter, come to page 246. Lord, your Lordship was right. There are only, Lord, my learned friend was right. There are only two forces, good and evil. Lord, the forces of truth and the forces of falsity. Please see, Lord, now how he treats it. Page 246. Now, Lord, page 246.
Impugned
25th of July, 2023.
Yes.
Now, my lord, if your lordship comes to page 246, your lordship will find the date of publication in Times of India, which is 27th of July. So it is published on 27th July, which means he gave it to Times of India the day before on 26th of July. Now, Lord, please see what he's publishing. So the cause title is there. This famous Mr. Pradyumna Mishra. Take notice that the Learned Commercial Court in Alipur has in the caption matter arising out of shareholders agreement dated 31st March, inter alia executed by and between Money Square, Satwa, etc. Passed an order on 25th July after hearing the parties to the SHA, Money Group, Satwa Group, whereby the parties have been directed to maintain status quo in terms of the SHA to the effect whereof is as follows. So now he says this is the order and this is what he publishes. A, not to give effect to any board resolution passed by the board of directors, including the alleged board resolution. B, not to convene any board meeting, etc., etc. All persons connected directly or indirectly with the special business proposed to be transacted at the EOGM and in particular issuance of NCDs on private placement basis in case of authorized share capital of Abbott and issuance of 0% optionally convertible preference shares on private placement basis are cautioned not to take any steps. Take further notice that any person directly or indirectly found participating in the special business proposed to be transacted at the EOGM, including and in particular issuance of non-convertible debentures, etc., etc. Shares on private placement basis or willfully disobeying, overreaching the status quo order in any manner whatsoever would be liable for action, etc., under contempt of court act. Now, Lord, please see what he does. But this is certainly not a laughing matter.
Yes.
Now, Lord, this is not a laughing matter. Please see, take courts. a court's order is misconstrued and a publication made. Now, more important, please turn the page now. But please come to page 247. I see. But if your lordship would go back to but please go back to page 246. Please see the bottom. I forgot to show your lordship a date. At the bottom, there is a date, 26th. Now, Mlord turns the page. Why this is important? 26th, he also files an application. Affirms an application which is at page 247. Your lordship will find that rubber stamp on the left side. Notice. Now, Lord, please come to the prayer at 251. On 26th, according to him, this order is mistaken and needs correction. In what manner? Please see, prayer A, the obvious typographical error or mistake in the order of 25th July, more fully described in letters B and C, be corrected and or amended and or modified in such manner as the court deems fit and proper. So on 26th, on the one hand, he says it needs correction. He does not say what he's saying it is. And on 26th, he writes to the newspaper saying that there is such an order. Now, what is the correction he wants? What prayer A says is Annexure C. Prayer A says he wants corrections as mentioned in letters B and C. Now, that, my lord, your lordship will get at page 266. This is how he wants the order corrected. Now, your lordship remembers para 13 and 14 of the order? Change, but don't. Now, the change which he wants is in para 14. Considering all, it is found to this court that at this stage when the court is in locus to determine an application under section 9, it is only to be looked at into whether the periphery of the provisions of section 9 and not more than that. In any case, opposite parties have come to make oral submissions, not in a position to file affidavit. Therefore, considering the same, it is opined that a status quo in terms of the SF, in terms of the SH, in question should be maintained till filing of the affidavit. See,
what was originally, what was the...
Lord, please see. Lord.
Data in terms of...
I'll read it for your lordship, not from there.
Yes, yes, we've seen it,
Status quo of the SHA. Excellent. And then, my lord, para 15, that be so, the court directed to maintain status quo in terms of the SHA based on the terms as delineated here and etc. till the returnable date.
Why would they do this? I mean, there must be some motive.
The motive is this. There is very clearly, even according to them, no injunction on the EGM.
No. Why would they initiate these actions at all? Why would they want to go back to the shareholders agreement?
But see, this much is clear. What this order means is not clear to us. It is not clear to them.
Subject to hearing Mr. Mitra, Mr. Pachavat,
yes,
this order will have to go. It's unreasoned. There's nothing.
Absolutely, there's nothing there. Nothing there at all. Not just that. Even according to him, this order is meaningless. It needs changing.
This application for correction or clarification is still pending.
Pending. They asked for interim order, which was opposed by us on the ground that there's appeal pending.
Let us hear them now. Let us hear Mr. Mitra.
Just give me one moment. But if your lordship takes page 250, one more para, I'll show. Follow. Yeah.
From 26.
Yes, yes.
Page 267, what is annexure D?
Lord, if I may read, Lord, para 8 once at page 250 of that application for modification. The petitioners, apart from having sent an email at 10:53, have issued a public notice communicating the gist and effect of the status quo order to all concerned, a copy whereof is annexed to and marked D. Now, it's not that one which I've showed your lordship. What was published. Now, my lord, please come to
267.
260.
27 तारीख का newspaper.
Now, my lord, please see, please come to annexure D, which is annexing at 267. Now, I've showed your lordship that this has been published on 27th. This petition is filed on 26th and affirmed on 26th. It certainly could not have had a newspaper publication of 27th. Lord, again, like I say, Lord, truth must prevail. So there's either been some tampering of the record or this is a false statement. A newspaper of 27th could not have been annexed on 26th. Now, but this is in long and short, not my submissions, but if I can just amplify, 5 minutes I'll take. And any of those things on which your lordships want an authority, we have copies over here. We have made photocopies and I have them marked copies. So, the first point is this is a unreasoned order. There are no reasons whatsoever. Your lordship has seen it. I've showed your lordship. Lord, I have judgment saying unreasoned order. Lord, has to go.
Anyway.
Yes, no, Lord, absolutely. I'm not citing it, not if wherever your lordships. Lord, second point is it's an unintelligible order. It cannot be understood. Even according to the other side, it's wrong. Now, Lord, I have a judgment saying exactly this. That if there is no clarity in order, Lord, the ordering portion must set out with clarity what is the relief granted. If not, it has to go. I have the judgments, I'm carrying it. Now, my lord, the third is after saying no relief claimed against me. I've showed your lordship the pleading para 3. This is turning back the clock to a position when I was not a shareholder. So the rights of new shareholders are now being overridden by a document which is torn up, thrown away, gone.
Yes.
Fourth, Lord, before passing an order of status quo, it is obligatory to first ascertain the status. And whether, my lord, at all this status as of 2011 could have been restored, and that too in the absence of Lord Ruddin, nothing on that. Lord, I am carrying the judgments on that. Again, the court must ascertain the status before passing an order of status quo.
Yes.
Next point. Court has not restored a status quo ante as of 2011, which cannot be done. Now, Lord, particularly as, Lord, I'll give your lordship the factors, I've summarized it here. Original parties are not there. Ruddin, which was a 40% shareholder, is gone. Second factor, new shareholders have come in, including us. who are not parties to the shareholders agreement. Third, directors of Satwa Group, my learned friends group, which is 20% according to them, but 1.5% as per his chart. His director has resigned and gone. Next factor is the company had become a NPA, proceedings were taken, order successfully obtained, resolution with the bank. Not all these factors, not all seem to go out of the window of the status quo. Not that agreement comes in. Next, shareholders agreement torn up. Not all part of this, not status quo ante. Shareholders agreement torn up. That's the letter from Lord Ruddin Group. And the status quo cannot be restored if the paper is torn up and thrown away. Original not being disclosed despite repeated demands. Now, the law again, status quo ante, I don't say it cannot be granted, but it must be status quo as on the date of the filing of the proceedings. It cannot be restored to old time 2011, can't be done at the ad interim stage at all. Again, we are carrying the judgments for that. Then, shareholders agreement is not incorporated in the articles, therefore not binding, not on other shareholders who come into the company. That's Rangaraj's case again. We are carrying all this. Yes. Next, I am not a party to the arbitration agreement, a non-signatory. Now, next point is these reliefs can't be granted. Please take the prayers at page 49.
Why? Because of Companies Act.
Companies Act, Lord, your Lordship knows there is a line of judgments also saying certain kinds of matters are not arbitrable in their nature. And Section 430 of the Companies Act. Here again we are armed with the judgments.
This is 2013.
Yes.
2013 Act.
Yes. Your Lordship will find in the prayers, it challenges the appointment of directors, stay of EGM. The prayers will be at page 49.
Yes. Anything more, Mr. Bachawat?
Delay. Notice dates I've given your Lordship, 30th of June for a meeting at the end of July. He comes 2 days later. 2 days before the meeting, rather, not 2 days later, 2 days before the meeting. In addition, a suit has been filed by us.
Why?
By us, Mayur Pank. Subsequent to it, but today is the subject matter of a suit. Then, delay in filing arbitration. Provisions of Section 9(2). No intention to arbitrate. And today what he challenges, that restructuring plan by issue of those non-convertible debentures that has been affected, bank has been paid off. That's something I think Mr. Banerjee appearing for the, or Mr. Shah appearing for the company will tell your Lordship what has happened there, but it's really become infructuous. This is more or less my submission. I have not placed the judgment because this is not the kind of matter which needs to be gone into in any detail.
I know your Lordship has a 3 p.m. fix, but let me, may I?
3 p.m.
Just once, that can 3 which I showed your Lordship is a Order 41, Rule 27 application where I had annexed those documents. Because that happened after the appeal, those documents which I showed your Lordship. So your Lordship will perhaps not allow those documents to be used. And there was an interim order your lordship had asked me, but because of that newspaper publication, they were restrained from making publication. Now both parties were restrained from making any further publication. So that's what. What? Lord, the interim order is at page 912. If your lordship wants. And the last submission, conduct, I've showed your lordship. Conduct in this case should weigh heavily, not at this stage of the proceedings. Those are my submissions.
Agenda was, my lord, the just one submission. My lord, the agenda was to, my lord, pass a resolution, my lord, for restructuring the debt with the Punjab National Bank. My lord, that debt has now been restructured. The debentures have been issued. Now, my lordship will see from the note in the resolution itself that, my lord, if this debt is redeemed within the requisite period, then, my lord, there is no dilution of shareholding. So, my lord, the apprehension expressed in the Section 9 application, that is really, my lord, grossly premature. And, my lord, we have filed a supplementary affidavit stating that, my lord, the EGM has been convened, resolution has been passed, the restructuring has been done, and, my lord, these debentures have been issued. Convertible debentures.
Could I have your lordship's leave for more?
Yes, yes.
Only this, my lord. Only wanted to add this portion, my lord. When I move my appeal independently, I'll address your lordship at length.
So convertible debentures have been issued. It has been restructured.
Yes, my lord.
For that, no EGM was held.
No, EGM was held, my lord. That is the EGM that was sought to be interdicted in the Section 9 application. The notice of EGM was issued, my lord. They wanted to interdict that EGM. Sought to be held.
I see.
So, my lord, in our
the status quo order was there, but you held the EGM.
Yes, my lord, because it said status quo with regard to the agreement.
Right. No, we are not on that. Yeah. All right. So what remains of the Section 9 app?
That is only what I wanted to illustrate before your lordships, my lord.
Let us hear them.
I'm grateful. My lord, in Section 9 also there's an averment that they are claiming damages.
Claiming?
Damages, my lord. In that case, my lord, whether any injunctive relief at all is possible, your lordship will consider.
Anybody else on this side? No. Yes, Mr. Mitro.
Tanko Banerjee was
led by Mr. S.N. Mukherjee. Lord, we'll submit after Mr. Mitro submit.
they are all on one side.
Why? He says you are all on one side, the bad side, evil side.
No, they're the good side. We are the evil. They are the good side. We are the one. They are the evil. Good is always more. So 4 on that side. Evil is less.
I wish that was right. Good is always more. No, then let's hear you what to do. Huh.
Well, 2011 is the shareholders agreement.
1 second. You are Satwa and which other parties?
Satwa,
R6, R7.
R6 and R7, Mayur Punk.
Not Mayur
I'm sorry. Prajapati and Lakshmi Narayan.
Satwa, Prajapati and Lakshmi Narayan.
हमारे constable
Yes.
Well, please. Now, there's the shareholders agreement between 4 entities: Raddin, Fabworth, Money Square, and Satwa. Fabworth has this money. Fabworth is the company. Raddin has transferred its shares, its 40% shares, in the year 2015 to Money Square. to Money Square's nominee. I will tell your lordship. This agreement contemplates the parties to be bound as well as the affiliates of the parties. There are shares of these. Originally, it was supposed to be 40 money, 40 Raddin, and 20 Satwa. Permitted transfer is to the affiliates of each other or to your affiliate. Permitted transfer, and the affiliates would be bound by all the terms of the shareholders agreement. This is 2011. Now, Raddin transfers to the affiliates of Money Square and goes out in 2015. From 2015 onwards, there is 80 and 20, two shareholders, parties to the SHA and their affiliates who, as per the terms of the agreement, are bound by the shareholders agreement. Now, my lord, of the three parties, now Fabworth, the target company, Money, and Satwa. Money, in its appeal, has said that this agreement subsisted till 2021 October. Why 2021 October? Because Vijay Agarwal, my nominee on the board, resigned on that date. So this is Money Square's case. Now, so far as Fabworth is concerned, their first time they took the point that the agreement has been abandoned was in 2023 July. Now, what does this shareholders agreement provide for? This has got three negative covenants. That without the consent of the shareholders, there cannot be any increase in share capital. There cannot be any increase in authorized share capital. Authorized share capital, paid up share capital. And the borrowings exceeding the paid up share capital. For these three, you need affirmative votes of all the shareholders. By all, I mean the two groups. And the company is bound by it. Now, there is also a clause that each group will be entitled to have its nominee on the board. And if for some time a nominee steps down and is not there, that will never amount to waiver of the right to nominate. And whenever a nomination is made, the others will appoint. So there has to be a nominee on the board. Number one. Number two, there has to be these affirmative votes for increase of authorized share capital, paid up share capital, and the borrowings. I'm more on the paid up share capital, which is of concern to me. That is yet to happen. Now, my lord, so what happens is in September 21, the Sarfezi proceeding is quashed by the High Court. In September 2021. October 2021, my nominee, Vijay Agarwal, then resigns from the board. And for 2 years, for one and a half, 2 years, there is no nominee on the board from my side till June 2023, when I nominate Mr. X, Mr. Vineet Poddar, Mr. X on the board as my nominee. They do not fill up. Fabworth then writes in the month of July saying that you will not be able to nominate since you have abandoned, since the agreement has been abandoned. So, but in between, there is a board meeting held towards the end of June 2023, and an extraordinary general meeting is called, where they propose to increase the authorized share capital and increase and issue further shares, paid up share capital, which is, and as also make borrowings. The ground being in the notice of the EGM is that the promoters are not willing to put in more money. This I received on 30th of June 2023. Immediately I write, sometime middle of July, that this is incorrect, that the promoters are not willing to put in the money. I am willing to put in the entire money which is required, which you are getting from an outside shareholder. Entire money on the same terms, and I said on better terms. In July 2023, 14 July 2023. To that, there is this denial from the company that you have abandoned. Immediately thereafter, in the last week of July, we filed a Section 9 petition saying that this negative covenant is there. You cannot act contrary to the negative covenant by increasing the authorized and paid up share capital of the company, which they intend to do through convertible debentures. Now, we moved the application in before the EGM is held at the earliest. We move it on 25th of July 2023. We filed on 24th, we moved on 25th. And 25th July, the court holds, after considering everyone's submission, that this is a fit case for restraining the resolutions which are being proposed in violation of the negative covenants in the shareholders' agreement. The court further holds that unless this order is passed, there would be irreparable loss and prejudice suffered by the petitioners, because I will be reduced from 20% to further minority shareholder, and my rights and all my rights under the shareholders' agreement will disappear. Now, this is the specific finding of the court. This is a judgment of the court, if I may say so, after considering the facts. But while passing the order, it is said status quo regarding the, instead of EGM being held contrary to a shareholders' agreement, status quo regarding the shareholders' agreement. But the judgment says that this is a fit case for an injunction, for injunction being passed on the. In fact, I will place that one paragraph of the judgment which makes some kind of sense. So, my lord, we do two things. On 26th itself, we file an application, or maybe 27th, for correction of the order, saying that the judgment, your ratio is contrary to the ordering part. Please correct it. That on that day, in fact, we were never realized that this was that the court would have meant otherwise. It was a formal correction, we thought. To that, we were surprised to find that this Mayur Pank, who is an affiliate, that's our pleading, but who claims not to be party to a shareholders' agreement.
Who's affiliate? Money's
affiliate. Now they come and say that I have already filed an appeal. So, recording that, the court does not, on 27th of July, clarify the order. And we then immediately file appeal. Now, my lord, but before we can file the appeal, the very next day, the appeal was filed by this Mayur Pank. While they filed the appeal, so allegedly being aggrieved by the order of the Honorable, by the learned commercial court, they file a suit thereafter saying that there is no order. So the shares have been issued, the EGM held, and all of them say, all of them are very aggrieved by the order, but all of them make the statements in different affidavits. Since there was no order, the EGM was held, and its resolutions passed and given effect to. While our appeal, which was possibly one day later, or later than, because we saw this when we moved for correction the next day, when they say this, we filed the appeal one day after that. We are the ones who, in spite of the order in my favor, there is the operative part is contrary. Now, Malad, this tearing up story, tearing up of the agreement and the agreement disappearing in the process, that story is not run by any of the parties to the shareholders agreement.
We will not take that into account.
Because if a conveyance is torn up,
Mr. Mithru,
let me know my lord's thoughts. That's most important.
Thought is what remains in your section 9.
What remains is
what you tried to restrain has been done.
Has been couldn't be done, or the EGM has been held.
That's what you tried to restrain.
Has been done, yes.
Has been done.
Has been done. Now, the only thing remaining is twofold, whether one can take advantage of an obvious mistake in the order. So anything done when this obvious mistake, when the order says in the preceding paragraph, that's one part.
Mr. Mithru, let us respond to that. Also know what we think about the order. Completely incomprehensible, completely confusing. The order makes no sense. We are making this statement consciously. We don't want to make any stronger statements.
Well, in fact, last day said, my lord is aggrieved by the order. My lord, that was my lord's statement. Don't worry, Mr. Mitra. I'll be hearing because the order, I am aggrieved because we are aggrieved by the order. But amidst that, I would like to show that one paragraph makes some sense where the operative part is.
What we can do,
Well,
we will not dispose of the section 9. If you like, if you want to press for other prayers, whatever, we'll set aside this order, send you back to the section 9.
One thing is yet to be implemented, my lord. That's something I shall be. That's the other part.
Yes.
What is yet to be implemented is the conversion of the convertible debentures into shares, where the paid up share capital will be increased. That has not yet happened because as per the returns, that has not yet been filed with the Registrar of Companies. I shall be really pressing for that much at least. If I can show, my lord, that I have really a cast iron case.
Not before us, before the learned trial court.
Well, may I make one endeavor to show it for this much, that there will be no further status quo being altered between today and the day when the Section 9 application is heard. Because that's something. Well, all I can say is that if I had convinced my lord that I had a very strong prima facie case, then in that case, I have been, let me call myself unlucky that this order was passed and they were smarter than us by filing the appeal one day earlier. But my lord, may I at least pray for this, since what has not been done, whether the status quo can be preserved as on today. Lordship, may I? Well, may I just show a few clauses and then there's one paragraph from the judge.
Yes,
May I just show, my lord, firstly, paragraph 13 of the order in the compilation.
Just indicate, Mr. Mitra, indicate to us roughly how long. We are not rushing you. We want to plan out our proceedings.
Well, I will take, since Lordship has expressed your mind, I will try not to ask for more than what. Well, maximum, I'll try for. This is maximum half an hour. They had taken 1 hour, I said maximum half an hour.
Today you will not conclude because it's
I know that.
Let us ascertain if the 330 learned lawyers are present. You are from Delhi? You are from Delhi.
Well, I can, since over 3 years, it's been fighting over who will speak first, and it must have been heard 25 times at least.
Mr. Mukherjee was arguing in that
Mr. Peshawar, there's a mistake.
Yes.
There are 2 matters fixed at 3:30 today.
I believe so.
Now, the Delhi matter, because counsel has come from Delhi, we'll call first. It may not be effective.
Oh, yes. Very well. I'll be here, but Mr.
Right.
Mukherjee is the one making some.
Who's for the other side? The Delhi matter? Who's?
Delhi matter, sir, is there.
They may not have come till now. That's also
Why
possible.
you carry on till 3:30?
Okay, carry on till 3:30.
Carry on.
Lordship, kindly see the first volume of the compilation. The order impugned at paragraph 13. The order impugned, which starts at page 1. Paragraph 13 of the order, if I may just place, because this is where the order is. From the foregoing discussion, it is summed up. I'm adding a few EDs and commas and full.
Please do.
It is summed up that the instant application has been filed in view of urgency, that the matter, inasmuch as the respondent number 8 company, who's a party, at the behest of respondent number 2 Money Square and respondent 1 to 5 Money Square's affiliates, has by letter of 12 July 23 refused to adhere to the positive obligation cast under clause 6A of the SHA to appoint the nominee director of the petitioner number 2 and respondent number 6 and 7, they are my affiliates. Contemporaneously, the respondent numbers 1 to 5 and respondent number 8 company are now proceeding to hold an EOGM in pursuance of the notice dated 30th of June and decide on reserved and or affirmative vote matters falling under clause 6b, 4 and 8 and 6c2 of the SHA respectively, which shall result in the valuable rights of the petitioner number 2 being irreparably damaged and or prejudiced. This is the part where, in my humble submission, this is the finding after recording submissions up to paragraph 12. And this is what the court had intended to pass. But then, as your lordship rightly pointed out, the court could not express itself in paragraph number 14. Because page 7, the second line, therefore considering the same, it is opined that the status quo of the SHA, that is totally inconsistent with the learned judge's finding at paragraph 13. Now, lordship kindly comes to just say 2 or 3 clauses from the SHA. Lordship kindly come to the negative covenant at page. Yes, well, lordship, may I, since the one they have annexed very rightly, very small, is not legible. The shareholders agreement in the compilation. This is the shareholders agreement, which one can read.
Or 31st.
Lordship, this shareholders agreement, lordship, kindly come to clause 6A. 6B. 6B Roman 9. Please, let me just.
Since this is a clear and enlarged copy, my learned friend must be having the original. Let us show where this photocopy has been made from. Let him show where it's been made from.
Mr. 6 clause 6B, Roman 8. Any issue of new shares. Reserved matters B, decisions on the following matters at the board meeting of the SPV shall not be taken without consenting vote of Mani, Raddin and Satwa. Raddin has gone to Satwa. 6 Roman 8, any issue of new shares or debentures or debt instruments, including bonus shares. This is a board meeting negative covenant. Coupled with Roman 3, 6 B3, increase of the company's registered share capital, and Roman 4, increase or reduction of share capital of the company. This is at the board meeting, and general meeting, it is 6C. Next page. Page 10, affirmative vote. Notwithstanding any other provision of this agreement or any power conferred upon the board, the act or the articles, the parties shall ensure that the SPV shall not undertake any of the matters specified herein below unless such matters shall have been approved by an affirmative vote of at least one of the nominees, each of Mani, Raddin and Satwa. If the following matters are put to a general meeting of members of the SPV, they shall require the affirmative vote of the shareholders of Mani, Raddin and Satwa at such general meeting convened and held in accord with the provisions of this Act. Now, Lordship, kindly see Roman 2. Authorizing the issuance of any new equity shares. C, Roman 2. B, Roman 3, 4 and 8. And C, Roman 2. And so far as the borrowing is concerned, it is back to page 9B. Back to page 9B. Roman 11. Any proposal to borrow in excess of paid up capital and free reserves of the SP. And now, Lordship, so far as the board is concerned, the previous page, page 8, 6A. Board composition. The board of directors shall consist of 4 directors, out of which 1 director shall be the nominee of Mani, one director shall be the nominee of Raddin and one director shall be the nominee of Satwa. And the fourth director shall be the nominee of Eman MGA, being 26% shareholder that they have also sold out. Now, except where a director is required by law to vacate, no director nominated by any party shall be removed during the term for which such director was elected without the consent of the party which nominated such director for appointment on the board. Notwithstanding the foregoing, a party may ask for removal, substitution, or recall for any reason any of the directors nominated by each party agreed. Now, last para of 6A, page 8. In the event a vacancy shall occur for any reason, yes, page 8, last paragraph, it's 6A. In the event a vacancy shall occur for any reason on the board, each party agrees to cause the SPV to immediately convene a meeting of the board of directors and cause its representative to vote so as to appoint a replacement. Next sentence is very important. The failure to do so shall not constitute a waiver. Firstly, this situation never arose. Failure to do so shall not constitute a waiver of such right, nor shall it prevent the exercise of such right prospectively. Such vacancy shall be filled up by an individual who shall be nominated for appointment by the party that had.
Then, let it run in the list wherever it is. Dekho.
I'm grateful that I'm being able to get myself heard, whatever may be the outcome now.
Of course.
Last 25 times, at least, the matter has been, there are part-heard markings in my brief, but then nothing could be.
25 part-heard markings?
25 times. This is the 26th.
Good.
No, not good. Not good. Not good. Not good. Otherwise, I wouldn't be unhappy. Same position. হয়নি ওটা আমার ভালো হয়নি মক্কেল রাজি হয়নি
এই চারটে একসঙ্গে আছে অ্যাকচুয়ালি আইডিয়ালি প্রত্যেকটাই আলাদা ডিট্যাগ করে পরপর দিয়ে দাও হ্যাঁ বুঝতে পারছো কি বললাম আলাদা করে একসঙ্গে থাকবে কিন্তু আলাদা আলাদা থাকবে উইথটা করো না তুমি আজকে ময়ূরপঙ্খের যে অ্যাপিলটা আছে ওতে অর্ডার করো ইউ হ্যাভ আ সেপারেট অ্যাপিল
Yes, I am the real appellant. I am this item number 5 in the list.
Third learned counsel for the parties, Mr. Bachawat, learned senior counsel representing the appellant, concludes his opening submission. Paragraph, Mr. Mithro.
Shah was also there.
Mr. Shaha, learned counsel appearing for Fabworth, also makes submission. Paragraph, Mr.
He's also an appellant. He also has an appeal.
Appeals will be listed separately. This tagging thing confuses. Mr. Mithro, learned senior counsel representing the Satwa, SATTVA.
Satwa Group, Lordship.
The Satwa Group begins his argument but does not conclude. Paragraph lists the matter once again.
But Mr. Mukherjee also appears. But
on that side.
Note. No, the appearance will have to be given separately. কালকে রেখে দাও লিস্টে যেখানে আছে তার পজিশন
কি হয়েছে সেটাই বলছি তো
ঘাবড়াচ্ছ কেন দাঁড়াও না এবারে সাতবার যে অ্যাপিলটা আছে এটা সাতবার অ্যাপিলটাই লেখো Mr. Mithro, learned senior counsel representing the Satwa Group, begins his submission but does not conclude. করে আবার কালকে লিস্ট করে দাও অন্য ম্যাটার গুলো কালকে
correct the cause title that respondent number 2 was missing. Lord, it's not there. Please give us.
ময়ূরপঙ্খে দিয়ে দাও ওখানে leave is granted to learned advocate on record for the appellant to correct the cause title by incorporating the name of the respondent number 2. Cause title of the appeal papers. Chalo. Double fee পাবে? Double fee. Your Lordship. Would your Lordship pleasure to release the other matters of my Lord case? Just see, possibly we'll release. Just bear with us for 5 minutes. Pleasure. Mr. Dashgupta, you are appearing for Steel Authority. Have you filed your written notes of argument?
But,
Who is for your other side? Learned.
for the respondent.
Have you filed your written
No,
notes?
we have not filed, Lord.
Please bring your written notes. We'll hear you only after that.
Very well. How many pages? Any, Lord?
No, but as short as possible. As short as possible.
Very well. 5 pages? Lord.
Yeah. 5 is fine.
Whichever, Lord,
5 is
short
fine.
as your Lordship's perception, my perception may not be the
You're
same.
right, but
That's why
5 is fine.
5 is fine.
5 is fine. When will you come back? Just tell us.
We have a written note, but it's fairly long as I see it.
So please ask
we will truncate it, Lord.
Ask. Work on it. And
We will work on it. It's running into, I think, 18 pages.
that's frightening.
So, Lord, we will truncate it and
Give us a date of your convenience.
can it be, Lord, sometime in September?
It can be.
19th, if possible, if it's convenient to the Honorable
No
Court.
problem. 19th is, look up your diary. Diary to
Is
the.
not? There's a problem?
দুজনে কৌশিক কোথায়?
Time.
Yeah.
Yeah.
At the same time बोल दीजिए सर we will have to
अच्छा कहाँ का?
commercial court राजा
अच्छा तो फिर किसी और ने? फिर मेरे पास कोई डेट नहीं है यार।
नहीं
अक्टूबर
पहले 3:30 बोल देते
Lord,
হবে না।
3:30.
Could it be Friday 3:30 is very dicey in our court.
I see. So whatever.
So any other day 3:30 is fine. Can it be 18th or next following Monday?
Lord, following Monday, Lord, then there are holidays in Delhi and.
What about 18th?
Lord, can it be then 11th if it's possible?
Yes. দেখো ফাঁকা আছে?
11th is okay. Lord?
Yes.
3:30.
3:30.
Subject to
11th. Okay.
on the morning.
Let this matter be listed, Likcho. We listed again on September 11, 2025, marked 3:30 p.m. So paragraph on the adjourned date, learned advocates for the parties are requested to file short notes of arguments, short in capital, block letters, underlined, short notes of arguments. And they may exchange the same.
Lord, within 2 weeks or
Before
the next day.
Before the next day.
Great. Great.
Thank you.
Great.
Our court officers get very excited when this matter is called on. They always need models.
But I also get excited. I've asked them for a copy which I can take home, but Mr. Ratnanko Banerjee is reluctant to part with it.
Yes, I love the train track and the cars.
He's reluctant. He's decided he's going to grab it.
Mr. Mukherjee, can we release your
Yes. Yeah.
for the day?
I'm starting from para 40. The memorandum of appeal ta deven. What all do we need first? Memorandum of appeal and then
আর মেমো বলো না, মেমোরেন্ডাম কেন না, মেমো খালি লইয়ার করেছি।
in Millard on the last occasion, where Millard a communication of April 4, 2024.
Could I have your lordship sleep for 10 minutes?
That Millard communication was a fraudulent and deliberate attempt by the railway to underplay a huge new project which has to be undertaken for reviving the so-and-so, which had ceased to be. The expressions repair, etc., diametrical opposite to the factual work required at the local. In order to revive the pipeline, the underpass had to be crossed, which cannot render the underpass totally unusable, rendering the valid and subsisting Whaley permission and agreements viable. Now, my lord, two things. My lord, I had commented, my lord, on the last occasion. My lord, this communication which I shall place, my lord, on the basis of which, my lord, the learned judge goes on to hold, my lord, that this was, my lord, a fraudulent and deliberate attempt by the railways to underplay. My lord, really, my lord, there could be no such finding, my lord, at all, particularly when seen in the context of the communications which had been expressed, my lord, exchanged between the parties. Secondly, my lord, without there being an allegation, my lord, to that effect, my lord, in the writ petition. I'm not saying, my lord, that fraud cannot be, my lord, noticed, my lord, by a court or anything. But what I'm saying is, my lord, here, my lord, it was nobody's charge, my lord, that it was a fraud at all. None at all. And, my lord, to say, my lord, that the crossing is unusable, my lord, without, my lord, any evidence, my lord, to such effect. And I've shown, my lord, the photographs. Even today, it's being used with the structure there. Not just that, the road for, my lord, trucks, my lord, jeeps, motorcycles, and, my lord, the railway tracks are also over that crossing. Now, my lord, I come to para 40. Kindly see. In both the communications, as well as the agreement sought to be entered into with respondent number 6, that's, my lord, my client, the railway authority seeks to give out an impression in tandem with the respondent number 6 that the permission was given for reviving an underground water pipeline. The said attempt itself evidently is to bypass the effect of subclause 12 of clause 1033 of the Railway Engineering Code, which provides that in all cases of Whaley facilities, except ROBs, RUBs and underground pipelines, no construction, whether permanent, quasi-permanent or temporary, other than a kacha or pakka road in cases the facility is expressly given for the same, is to be permitted. Kindly mark the words, on railway land. Now, my lord, my first submission was, my lord, that your lordship recalls, my lord, this is 1.17%. My lord, out of 2250 meters, my lord, 2.25 kilometers, only 38 kilometers are being taken, my lord, overhead.
Meters.
38 meters are being taken, my lord, overhead, for the sole purpose of ensuring that nothing happens to the RUB. That nothing happens. And my lord, that it's still an underground pipeline. This is, my lord, an unavoidable, my lord, case. So, my lord, really, my lord, it continues to be an underground, my lord, pipeline. And my lord, the learned judge goes on to hold that no, it's overhead, and that is not permitted at all. Without, my lord, considering, my lord, the, my lord, business realities, my lord, of the situation. What is it in effect? And my lord, secondly, my lord, there's no construction on land. My lord, in fact, my lord, what is happening, my lord, they have their, my lord, underpass. On either side of it, my lord, there's a concrete structure which goes up to, my lord, the level of the land. And on that, my lord, are, my lord, the steel structures, my lord, which are placed so that the pipe goes over it and does not rest, my lord, on, my lord, the, my lord, underpass. Now, my lord, then, my lord, the learned judge goes on to hold if any such construction comes up subsequently, the same should be immediately removed as soon as noticed and the wayleave facility discontinued with. And ROB has been defined as in the said code as road overbridge and RUB as road underbridge. Construction now sought to be made by respondent number 6 is neither of the two and as such does not fall within the purview of exceptions. By admission, respondent number 6 gives out that the construction now required would involve an overhead structure, which again would not be an underground pipeline. My lord, my respectful submission, my lord, is, my lord, one needs to, I had shown, my lord, the railway code 1300, that it permits overhead. It's not that there is a complete bar. In any event, this is a revival of an underground pipeline. And my lord, they are the ones who are being accommodated. Now, my lord, the impugned wayleave permission has been given specifically for repairing and reviving and renewal of wayleave permission to operate an underground pipeline and not any overhead structure. By no stretch of imagination can an overhead structure be built over the railway land as defined as an underground pipeline. Thus, the very effort on the part of the railway authority and the respondent number 6 reeks of a surreptitious and malafide effort to bypass the railway engineering code as well as the master circular operating in respect of railway lands, which comprise a policy decision taken by the railway authorities and have the status of statutory guidelines. The respondent number 6 seeks to have the cake and eat it too. The impression given in the wayleave permission and the communication is that mere repair work is to be done to the underground pipeline and a wayleave permission is to be given for such purpose, whereas the structure shown in the map submitted by respondent number 6 clearly contemplates an overhead construction over railway property. Such attempt is barred of several counts. My lord, clause 1033, subclause 12 debars any such overhead construction. Wayleave permission sought to be given is a fresh wayleave permission in the garb of a renewal, which cannot now be given in view of the intervening underpass of the petitioner, regarding which two sets of wayleaves and agreements subsist between the petitioner and the railways. The effect of the impugned grant of permission cannot be renewal as described in the permission, since the tenure of the previous wayleave permission expired long 7 years back in 2013, and there was never any application for renewal filed or pending at any point of time. My lord, here I have shown, my lord, from the list of dates, my lord, reference to BIFR, that abating, my lord, because of amendment, my lord, in the law, then a section 10 application, and my lord, when, my lord, it gets, my lord, admitted, my lord, to corporate insolvency resolution process. And I've also shown that while my wayleave permission was subsisting, my lord, the respondent, the writ petitioner respondent before your lordships, my lord, had applied, my lord, for, my lord, permission, which was, my lord, granted. Now, my lord, coming to the other objection, and this is very important, taken by the petitioner regarding violation of subclause 3.2 of clause 1033 of the code, the same would involve a factual consideration as to whether alleged non-feasibility of the provisions of water supply applies in the present case. Although it is alleged that the Kongshaboti River nearby furnishes such alternative source of water, evidence regarding that and as to whether use of such supply is a practical alternative cannot be undertaken. So it's a question of fact. My lord, an assessment, my lord, has to be made. Learned judge in that case says, well, the writ court should not be doing that. But my lord, whether, my lord, it's actually a renewal, my lord, of, my lord, on a revival of an underground pipeline, my lord, the learned judge only looks at, my lord, the portion which is above, my lord, the underbridge, and says, by reason of that, my lord, the entire Whaley permission granted to, my lord, the writ petitioner becomes infructuous. Now, my lord, kindly see. The other argument advanced by respondent number 6 is that the petitioner is trying to frustrate the resolution plan which has been approved in connection with the CIRP initiated by respondent number 6. Clause 15.414(2)(a) of the same provides that the resolution applicant prayed that upon approval of the resolution plan by the adjudicating authority, and since the resolution applicant would require the corporate debtor on a going concern basis, subsisting consents, licenses, approval, entitlement, benefits, and privileges shall be deemed to continue without disruption of the benefit of the corporate debtor. The resolution process itself commenced on 8 January 2018, whereas the Whaley permission of the respondent number 6 for its prior pipeline had expired in July 2017. Hence, even from the inception of CIRP, there was no subsisting permission or consent or license in favor of respondent. Resolution plan was approved much later, and as such, the already expired Whaley permission of respondent number 6 could not come within the purview of subsisting approval. Thus, the very premise of the argument of respondent number 6 that resolution plan is sought to be frustrated does not have any legs to stand on. My lord, both were competing. They lost out. We got it. Then, my lord, when we come, my lord, and seek revival, and before that, they wanted liquidation. They were willing to buy. Having failed in, my lord, their pursuits, my lord, then, my lord, when we come there, my lord, till 4th April 2024, my lord, it goes up. And then, my lord, this is, my lord, a writ petition file. My lord, saying railways could not do this. This is in violation of railway code and master circular. Now, my lord, that apart, the clean slate theory propounded by the Supreme Court and followed by several high courts in respect of approved resolutions plan under the IBC applies only to efface previous debts and liabilities of corporate debtor to enable the successful resolution applicant to revive the concern with a clean slate. However, the said legal fiction cannot be doubly applied to generate another legal fiction of creation of new rights, which is entirely dehouse the ambit of the IBC itself. The rights under different laws than the IBC cannot be deemed to be created or permitted to be created under a resolution plan, since such an interpretation of law would confer powers on the authorities prescribed under the IBC, which are not vested in them by law. Hence, even apart from the fact that there was no subsisting permission in favor of successful resolution applicant at the relevant juncture, no new rights could be created or so-and-so merely by virtue of approval. In embassy, property so-and-so and others reported in so-and-so relied upon by the petitioner. Supreme Court held that in the light of statutory scheme as culled out from various provisions of the IBC, it is clear that wherever the corporate debtor has to exercise a right that falls outside the purview of IBC, especially in the realm of public law, they cannot through resolution professional take a bypass and go before the NCLT for enforcement of such a right. The said proposition is fully applicable. In view of the railway authorities having them, my lord, now, my lord, here I want to just digress for a moment. My lord, kindly have a look at, my lord, the clauses, my lord, of, my lord, the resolution plan. My lord, this is, my lord, very important. My lord, if your lordships kindly come, my lord, to the resolution plan once, my lord, which is your lordship will find. My lord, kindly take the stay application. My lord, page 188, my lord. Now, my lord, kindly see 15.13. Upon approval of this resolution plan, all investments, including but not limited to the investment in key infrastructure facilities, statutory rights, licenses, agreements, registration, or any similar approval by whatever name called, and fundamental for running the business as a going concern shall be in complete force and valid. Well, this is 15.13. Now kindly see 15.14, assumptions. My lord, kindly come to the resolution. Applicant has prepared this resolution plan on the basis of certain assumptions set out below and has assumed that upon approval of this resolution plan by the adjudicating authority, corporate debtor and resolution applicant, as the case may be, shall be entitled to the following and shall be deemed to form a part of the order of NCLT. Now, my lord, kindly see next page, licenses, approvals, contractual rights and benefits. Kindly come to B. Clause B, my lord. For the avoidance of doubts, it is hereby clarified that all consents, licenses, approvals, rights, entitlement, benefits, and privileges, whether under law, contract, lease, or license, granted in favor of the corporate debtor or which the corporate debtor is entitled to. Now, my lord, kindly note this. Which were in place on the date of shutdown of the plant pursuant to lockout, that shutdown date shall be deemed to continue without disruption for the benefit of the corporate debtor for a period of 12 months from the completion date or until renewed by the relevant authorities, whichever is later. Now, what was the shutdown date? My lord, 2010. Now, my lord, what is being done here? You had a license. We had the right to, my lord, renew it. That right is not lost, my lord, in 2017. Now, my lord, why couldn't we, my lord, renew it, my lord, during its subsistence? Because of the state of insolvency, my lord, that, my lord, the company was in. So, my lord, 2017 was, my lord, the outer date, my lord, of, my lord, this license, my lord, which was for a period of 10 years from 10th of July. So, my lord, 9th of July, 2017, my lord, was, my lord, the validity of this. My lord, June 2010, my lord, Ram Sarup was shut down. This is the closure. Now, my lord, what happens? 2012, my lord, our net worth becomes negative. Mandatory reference, my lord, to, my lord, the Board for Industrial and Financial Reconstruction. It's left to them. Then, my lord, then, my lord, what happens? My lord, the reference got abated and the matter was carried to the appellate authority. Now, the appellate authority sent the matter back. Kindly see the list of dates, items 8 and 9. My lord, it got, my lord, referred back, my lord, to, my lord, the BIFR. Last hearing before BIFR was 24th November 2016. Lordship will find that as item 10. Now, my lord, 25th November 2016, my lord, within, my lord, Sika, if I may use that expression, my lord, stood abated, repealed, and, my lord, the reference stood abated. Within 180 days, my lord, IBC came into force on 1st December 2016. Within 180 days, a section 10 had to be filed. We filed the section 10, my lord, on 2nd of May, my lord, on 25th of May 2017, on which date the license is still in my favor. My lord, while, my lord, it is pending, my lord, my lord, application, my lord, they, my lord, while my license, my lord, is still valid, they make an application on 2nd of May for way leave permission, 2017. Now, my lord, what am I saying? I'm saying I have taken all the steps. I have this license in my favor. The resolution plan is saying license or any right to it. So, my lord, right to renew, my lord, I always have. That, my lord, is provided for. And, my lord, when there's a case of insolvency involved, my lord, embassy doesn't apply. My lord, I just want to show your lordships, my lord, that judgment, my lord, of, my lord, Gujarat Urja. What's the reference? দেখিয়ে দিচ্ছি তোমার ফিক্সড আছে চারটা My lord, kindly come to, my lord, paragraph
Click on the trade.
My lord, kindly take para 35.1 first, my lord. My lord, I'm showing your lordship the submissions, my lord, which were made, and then, my lord, the finding. 35.1. Section 60, I'm sorry, my lord. Section 60, subsection 5 must be interpreted in the context of section 25(2)(b) of IBC, which provides that RP has to exercise the rights for the benefit of the corporate debtor in judicial, quasi-judicial, or arbitration proceeding. Hence, if NCLT is conferred with the exclusive jurisdiction in relation to the corporate debtor, this section would be rendered redundant. This court in Embassy, hereinafter referred to as Embassy Property, has held that RP cannot sidestep the jurisdiction of other authorities and approach NCLT for enforcement of corporate debt. Although this judgment was in the context of a renewal of a mining lease by a statutory authority, the interpretation of 65 would not be limited to statutory authorities, particularly in the backdrop of so-and-so and so-and-so. In the present case, Article 10.4, now my lord, of the power purchase agreement. My lord, because of insolvency, my lord, the power was disconnected. Question is, my lord, whether, my lord, NCLT could have revived it, my lord, whether it was within its jurisdiction to do so or not. Has granted jurisdiction to the State Commission, the regulatory authority, to entertain disputes relating to power purchase agreement. Article 10.4 provides as so and so. Now, my lord, kindly come to 35.6. The submission of respondents, my lord, 238, my lord, of the report. The submission of respondents that property under so and so includes an actionable claim, and hence the dispute falls under the jurisdiction of NCLT is erroneous in view of judgment in embassy property. So, my lord, till now, embassy property, my lord, is fine. Now, my lord, kindly come to 38.8. My lord, the facts of this case are different from those of embassy and municipal. Unlike Abhilash Lal, the property in this case, long-term contractual right under PPA, is the property of corporate debtor and not the property of a statutory authority. Further, there was no violation of law when NCLT injuncted the appellant from terminating PPA on the ground of initiation of CIRP. In addition, the facts in Abhilash Lal dealt with public duty of municipal in respect of construction of a hospital. Further, there were existing defaults and a show cause notice was issued in this regard prior to commencement of CIRP. As opposed to this, in the present case, termination by the appellant is not on grounds of default, but solely on the ground of initiation of insolvency resolution of corporate debtor, and that too nearly 6 months after the admission of the application under Section 10. In embassy property, what was at issue was whether NCLT has jurisdiction over a matter which is in the realm of public law. In the present case, the decision of the appellant to terminate PPA is not a decision taken by the government or by a statutory authority in relation to a matter which is in the realm of public law. The decision of the appellant to terminate PPA is only because corporate debtor is undergoing insolvency resolution. The corporate debtor has not defaulted in supplying solar power to the appellant and otherwise not in breach of its obligations. Then, my lord, kindly come to, my lord, paragraph 74. Therefore, we hold, my lord, that's at page, my lord, 264, my lord. Therefore, we hold that RP can approach NCLT for adjudication of disputes that are related to insolvency resolution process. However, for adjudication of disputes that arise dehors insolvency, RP must approach SOENS. For instance, if the dispute in the present matter related to non-supply of electricity, the RP would not have. However, since the dispute has arisen solely on the ground of insolvency, and here there's not even a dispute. Railways have not, my lord, created, my lord, any dispute. My lord, I had, my lord, a license which can be renewed. My lord, I was before, my lord, the statutory authorities prior to expiry of the license. And I say, please treat this as subsisting when the resolution plan for a period of 12 months, and then I will go for a formal renewal. Now, my lord, which I did. I, my lord, applied for, my lord, renewal. Now, my lord, kindly have a look at, my lord, an order, my lord, of the National Company Law Tribunal dated 8th of January 2018. My lord, this is, my lord, in the stay application, page 137. Now, my lord, kindly have a look at, my lord, para 21 at page 145. ICICI Bank, your lordships have that para 21. ICICI Bank has stated in the objection that they were effecting recovery of substantial sum of money advanced to corporate applicant and owed to the applicant bank, which has taken all possible steps available to it under the law, including SARFAESI Act and RDBFI Act. It is also stated in the objection that corporate applicant had filed a reference before BIFR in so-and-so on the ground that more than 75% had already taken possession of secured immovable properties under the provision. The said reference was dismissed by BIFR. Corporate applicant aggrieved by such order preferred an appeal, which will stall the ongoing proceedings initiated by. Is also mentioned the objection of appellate authority remanded the case back to BIFR with specific direction to consider submission. Above mentioned reference was pending before BIFR, which abated on account of coming into force of SICA, and by virtue of that, etc. Now, my lord, kindly come to my lord, the order, my lord, which admits, my lord, at pages, my lord, 146 to 147. That they were interfering with.
So that will find starts at 206.
Now, my lord, kindly come to, my lord, page 206. Stay application, my lord. Yes. My lord, kindly take, my lord, page 206.
Para 5 first.
Yes, 1 minute. Now, my lord, kindly come to, my lord, paragraph 5. My lord, these are submissions. Then, my lord, straight away kindly come to paragraph 17, my lord, at page 223. Kindly now notice, my lord, the submissions here. Why I say, my lord, that the whole thing, my lord, really no locus has been moved, my lord, in bad faith. The submissions of Mr. Rohatgi that there is a firm offer of rupees 525 crores on 100% cash basis if liquidation is initiated and corporate debtors' assets are sold. Learned Senior Counsel Mr. Rohatgi during the submissions has referred to the above offer given by who? Orissa Metallics Private Limited, who was H2 in the CIRP. Orissa Metallics is the writ petitioner. Then now, Orissa Metallics Limited has also filed a resolution plan where H2 bidder, Orissa Metallics, had given a total bid of 1014.99 crores with an upfront payment of 281. COC accepted the resolution plan for H1 for a total bid of 670.50 crore solely on the ground that upfront payment of rupees 351 crore, which was higher than upfront payment of so and so. Orissa Metallics filed company appeal challenging the order so and so, which got dismissed by the order of 4th March passed by this appellate tribunal. Then we find substance in the submissions of Dr. Singhni that with the aid of the appellant, now Orissa Metallics Private Limited wants to have a second innings in the proceedings, due to which the appellant is pressing for liquidation of corporate debt. Now, my lord, we thus are of the view that the firm offer as contended by learned counsel for appellant for sale of corporate debtor has no relevance for consideration of the appeal. Much emphasis has been laid by Mr. Rohatgi on para 201 of the judgment. The NCLAT did not direct for liquidation of corporate debtor. Rather, it directed monitoring committee to start taking steps for implementation of resolution plan immediately. And in case SRA fails to implement the approved resolution plan, appropriate action be taken in. When we take into consideration steps taken by the monitoring committee after the judgment of NCLAT, it is clear that steps were taken by monitoring committee for implementation, and deadlock was created in the meeting dated 7 July 2021 when appellant himself came with the stand that unless payment of compensation interest is paid, he shall not participate in it, and thus he did not give his consent in implementation of the plan, whereas SRA, that's my client, was ready to implement the plan on his part. And my lord, the appellant, my lord, in this case, my lord, was, my lord, the asset reconstruction company, CFM, which had taken over, my lord, the, my lord, loans of, my lord, the banks. They started creating a problem. I'm not going into who is CFM, but my lord, appellant,
Yes.
my lord, the appellant, as well as, my lord, the, my lord, Total, my lord, it shows, my lord, that, my lord, my sketchy sketch maps were not understood at all by the learned judge, because I have not gone under their underpass. And I am being asked to restore it. The respondent number 6, that it shall restore the property adjoining the location which the petitioners under which has been already dug up and which full or partial construction has been. Such site shall be immediately be restored to its origin as it stood before an allied works. Now, my lord, we came on appeal. My lord, kindly have a look at the interim order. My lord, kindly take can 2, my lord, which is the exception to the report. '23. My lord, 21st May 2024. My lord, kindly have a look, my lord. We have heard the learned advocates for the parties. Since the appeal is required to be heard, as there are several factual and legal submissions which are to be made by the learned senior advocates on either side, the appeal is admitted for hearing. The learned single bench has directed demolition of the pipeline, which has been put up within a time frame. This direction, if implemented, it may render the appeal partially infructuous. Therefore, the order and directions issued by learned single judge for demolition of the pipeline shall remain stayed. The learned single bench has also made certain observations regarding the railway administration on the ground that their actions were malafide and fraudulent. For the time being, these observations and findings stand suspended and shall abide by the outcome of the appeal. So, my lord, findings of fraud, my lord, were, my lord, state. It appears that the writ petition was disposed of without calling for affidavits. More particularly, the stand taken by the railway administration was not put in writing. The question would be whether a permission which stood lapsed in 2017 could have been revived by the railway administration retrospectively, and if so, what would be the position of the persons who had acquired certain rights in the interregnum. That's, my lord, the legal question. Apart from that, the court should be informed as to whether there were any technical assessment done. Kindly mark the expression. Technical assessment done by the railway administration before revival of permission to take the pipeline above the railway underpass, which has been permitted to be constructed by the writ petitioner when the permission for the pipeline was not invoked. Let a report be filed in the form of an affidavit by the highest competent authority of the railway administration, duly supported with document, list the appeal on so and so. Now, my lord, the report of the railways, my lord, is on record, which I'll place, my lord, on the data is important. 26th আমার কালেঙ্গা আছে whole day arbitration. 26th I have a slight problem. I believe
27, 28.
28th is fine, my lord.
20th কি বার? Yes, 28th.
Obligation.
রেখে দাও, অভিজিৎ। Mr. Mukherjee, learned senior advocate representing the appellant, resumes his argument but does not conclude. Paragraph as requested, comma, list this matter once again on August 28, 2025, marked 3:30 p.m.
Thursday. আর আরেকটা মামলা